Yes.
Yeah, back to mention item number 3. If the matter has become infractious, my lord.
Item number 3.
My lord.
Mr. A.R. Talukdar, learned counsel for the petitioner, submits that the present writ petition has become infractious. To stop considering the such submission, matter stands closed, being infractious.
Item 41, can it be after 2 weeks, my lord? The sole respondent, my lord, I will have to implement the fresh one. In a contempt case. And for the
Okay.
petitioner.
Okay, Mr. Gogoi, learned counsel for pays for an adjournment to obtain instruction as regards implement of necessary parties. Full stop. Prayer is allowed. List this matter after 4 weeks.
Same item 4. I am appearing for NHM. I have got the additional instruction, my lord. I would like to file on short affidavit. I have taken the consent of the other side now.
Simple issue. You cut off that
Yes.
whether that was there, now it has been withdrawn.
As per some policy, my lord, they, my lord, otherwise not entitled. I will place it, my lord. The Central
But
government.
2015.
Hello?
2015 matter.
I understand. Let it be after, my lord, 1 week or say
Okay.
10 days, my lord.
Mr. Gogoi,
Additional affidavit, my lord.
learned standing counsel
Additional.
for health department submits that additional affidavit
Yes.
is being filed by the respondent department to bring on record
No.
certain important aspect
Lord.
for determination necessary for determination of this present writ petition. Accordingly, he prays for an adjournment. Prayer stands allowed. List this matter
After 10 days, my lord.
after 10 days. Give a date.
Well, affidavit will be filed.
Will be
Not
being
filed,
filed.
will be filed.
Being-
And I am appearing for NHM. not-
NHM, not standing counsel, NHM.
I am obliged, my lord.
16th of
My-
September.
Lords.
May I please? Item number 9, your lordship. The negotiation is going on for settlement of this case, your lordship. Because the litigants are brothers. They are brothers, so they are going to settle the
Who is for the other side?
matter. So I need some time because I have taken the consent from the other side. Bhuya is the
Mr. Upadhyay, learned counsel for the petitioner, submits that there is a talk of compromise between the petitioner and the private respondents are going on, in as much as the issue revolves around claim of respective shares from their predecessor in interest. Claim of respective share in respect of the subject land purportedly inherited by them from their predecessor in interest. Full stop. Prayer is allowed. List this matter
after 10 days. your
after 2 weeks on a date to be fixed by registry. Yes.
lordship.
Lordship, I beg to mention item 63 of today's supplementary list, Your Lordship. In
63. What is this in 63?
Vivahata filing matter, Your Lordship, and Lordship had directed the respondent to file the status report by an affidavit. So I have received one affidavit yesterday, and I am told they are filing one more affidavit
For
today.
being on the 1 month commission report, my lord, we are filing today, my lord.
Okay.
So
It is submitted by the learned learned government advocate that an affidavit has already been filed and another one is being filed during the course of the day to bring on record and status report. Status report. Full stop. In view of such submission, matter stands adjourned and be listed.
Lordship, 2 weeks time may be granted to file our response.
And listed after 2 weeks.
After 2 weeks.
After 2 weeks. In the meantime,
We'll file
the
our
petitioner shall be at liberty to respond to the affidavit so filed or being filed.
Lordship, grateful.
Lordship, I beg to mention a writ petition to be listed on 5/9/2024, Lordship, on Thursday, Lordship.
You will have to make a mention before the senior bench. If it is bench 4, bench 5, because this bench 5, then my Lord Justice Borua. Yes.
May I please, your lordship, I beg to mention item number 31. Lordship, allow us 4 weeks time to file our affidavit.
Learned standing counsel for GST prays for and is granted
4 weeks time.
4 weeks time to file affidavit in opposition. List accordingly.
Highly
Please,
obliged.
the lordship. Lordship, I beg to mention item number 14, it is daily list. Lordship.
1-4.
Yes. Lordship, kindly grant us 3 weeks time to file our affidavit in reply, Lordship.
Learned counsel for the petitioner prays for and is granted. How much time? 3 weeks time to file reply affidavit to the affidavit in opposition filed by the union.
No, filed by the, yes, Union.
Huh?
Sunshine, Lordship.
Filed by?
Affidavit in reply, Sunshine Industry.
No, affidavit will reply you want to file. Against whose affidavit?
Petitioner, Lordship.
You are petitioner.
Yes.
Somebody has filed an affidavit in opposition. Who filed this affidavit? Huh?
Union.
That's why you have said union. Yes.
May I please, your lordship? Big to mention item number 20, your lordship. Instruction to withdraw the petition, your lordship.
MS Bora.
G. Bora.
G. Bora, learned counsel for the petitioner, submits that she has instruction to withdraw the present petition. Full stop. In view of the aforesaid submission, the writ petition stands dismissed on withdrawal. Stands closed on withdrawal.
Lordship.
Lordship, I beg to mention item number 13, Lordship.
Item number
13, 1-3.
1-3.
In this
Yes.
matter, some instruction is awaited regarding the submission of FR by the investigation officer, Lordship.
Who are you?
Lordship, petitioner, Lord.
Wait for it.
Lordship, I have another prayer regarding item number 53, Lordship.
The
This
13
matter-
is rejected. We'll see. There was an this made a statement that FR was filed. If FR is filed, file. They made a statement. We'll have obtained the instruction over telephone, the number of the FR. That's all.
Lordship, regarding item number 53, Council Minister A. Sharma is out of station, Lordship.
Item,
May be
item
taken
number?
up after- Item number 53, Lordship. We have taken the consent of the other side as well. Maybe taken up after 2 weeks.
You are for?
Petitioner, Lord.
Why this matter is, this is hearing. 2015. Wait.
May I beg your lordship? Lordship, I beg to mention item 19, lordship. We have taken the consent from the other side. Finally, the matter may be taken up after 2 weeks.
Why?
Lordship, as my senior is out of station,
You are for?
I'm for the petitioner.
We'll have the instruction from the government whether it is actually illegal construction or not. If it will close it, if it is, they will do as per act as per law, giving notice to the respondent. Yes, next.
May I please, your lordship?
Hmm.
Lordship, I beg to mention for item number 17. Lordship-
1-7.
Yes, lordship.
Hmm.
Lordship, I have to file additional affidavit due to subsequent development, lordship.
You are for the petitioner.
Yes, lordship.
Learned counsel for the petitioner submits that there are certain subsequent developments, and therefore the petitioner would like to file an affidavit, additional affidavit
Yes,
to
lordship.
bring on the aforesaid facts on record. Accordingly, she prays for an adjournment. Prayer is allowed. List this matter
After 3 weeks, lordship.
after 3 weeks. Interim order, any? No.
lordship.
Okay, 3 weeks.
Obliged, lordship.
May I please, your lordship? Your lordship, I beg to mention item number 26 to withdraw the petition, your lordship.
Huh?
I beg to mention item number 26 to withdraw the petition.
Item number? Why?
Your lordship, I have been instructed to
Your name is there in the cause list?
behalf of Mr. E. Ahmed, your lordship.
E. Ahmed is present in High Court
Yes.
today?
Yes.
Mr. E. Ahmed, learned counsel for the petitioner, submits that he has instruction to withdraw the present petition. Full stop. In view of the aforesaid, the present writ petition stands closed on withdrawal.
That's all right.
Mr. Datta, waiting for that review.
Other matters are also there.
Okay. Review may not be possible today. So many matters will take a date,
Your lordship may fix a short date.
short date.
On that date, it may be dismissed.
Uh-huh.
So my client is troubling me so much.
No, I understand.
I'm required to block his number, my lord. He used to trouble every day. Anyway, my lord, your lordship may fix.
Why saying is that it is very difficult. Bench 4, bench 5, then going to That too with criminal appeals hearing, 2005 matter hearings are there. Because ultimately this will take some time.
Right.
It's a review, whether it will allow, not allow, but we'll have to give you a hearing.
Right.
Isn't it? That is the difficulty, that's why. Okay.
My lord, item 46.
Ah.
Let me take this opportunity, my lord, to mention because there is a delay of, I think, nearly
More than 1,000.
more than 1,000 days. So, my lord,
46, that review.
that may also take some time. So both the matters may be fixed in a same day.
That 45 and 46
Sorry,
both.
42, my lord,
42.
42. 42 and 46. 46 is review.
Okay, this is also review or what?
It's not review, but my lord, the transfer brief to me. Now I found that there is a delay of more than 1,000 days.
What is the matter here? Dismissed for default.
This restoration, yes.
Restoration.
dismissed for default, yes.
What
In
is the
42, I am
requisition?
the Lord.
Huh?
In 42, I am respondent 1.
You have filed an IFL condonation.
Condemnation.
Why delay condonation is required if it is a writ petition?
Lord, the
Where is the provision?
my lord, your lordship is very correct.
Where is
if-
the provision?
Yes, there is a provision of
It's a
CPC
writ
only,
court.
but we are borrowing quite unnecessarily.
Not necessary. There are anti-numbers of judgment, not applicable.
Right. Your lordship is very right, but then some court
No.
put a
This
such
is-
question.
There are judgment by our High Court. In fact, this court has delivered a judgment regarding that you cannot bring on all those technicality in writ court.
Very good.
Substitution, limitation. Where is the provision? It's a writ court. Why are you forgetting the power of a writ court?
The appeal court order is, judgment is also
Of
there.
course, the judgment is there. I have passed a judgment dealing with all these judgment. Relating to, of course, to a substitution petition.
Is all the
Order
same.
22. We said no, nothing.
Very correct. That will
And
make the matter.
in fact, I think I delivered a judgment on this question of limitation also. Delay is not the issue. Issue is whether you are negligent in approaching and all that we can under writ jurisdiction itself. This is a discretion to entertain or not to entertain. That is for that there is no application under section 5 is not
It's not there.
not necessary, and limitation is cannot be made applicable to power of writ jurisdiction. Anything to say? That's all. So why this matter is listed today? For restoration.
For restoration.
Okay, we'll see when method comes.
Obliged.
No, 46 is adjourned. We'll see, we'll pass an order later on.
Right.
Let the other side also. Yes.
Lordship, I am already on interim protection. On the last occasion, CD was called for.
Here, my lord, what I have checked.
Why this matter is listed before this court?
I have, it has to go to appropriate court, my lord, but because now, my lord, the reference has been made to the division bench regarding maintainability of juvenile regarding AB, my lord. So, division bench have said that the AB is maintainable in case of juvenile, my lord.
Okay.
That there is an order, just now I have.
That is Dasara Troy, division
Yes, sir.
bench.
Yes, yes.
Ah.
So now, my lord, on merit, my lord, then CD will be required, and why it is listed
Why
here?
it is listed?
That is also, my lord.
Moreover, your lordship,
Yeah, but.
Moreover will be later on. Why this is first time listed? Huh?
No, it's listed earlier in the.
No, it is not a bail for second time.
First it was listed, thereafter reference is.
Okay, one of the persons bail this court dealt with, Pranab Baroi.
given by this honorable court.
That's why.
That's why.
Case there is there?
Case there is not here, madam.
Okay,
So because it has come.
Okay, it is submitted by Mr. Goswami, learned additional public prosecutor, that case diary as called for by this court is not yet received, full stop. Accordingly, matter stands adjourned and be listed
On my lord, 12th.
12th of September.
12th, my lord, it will be some difficult, no?
Okay,
Madam.
already is in interim,
On my lord, 16, my lord.
16th of
16, 17.
September 2024. Interim order passal shall continue till then. Yes, Ali.
These two matters are may be taken in any other debate.
No, what is the issue here?
My lord, my technical,
That's why.
no. In second item, my lord, progress report is 0, my lord. I have file RTI,
No,
my
no,
lord.
what is the challenge in the past revision? Tell
My
us.
lord, my technical bit was rejected.
Your
With the
technical bridge is rejected. This is one.
lordship.
Second, what is the second writ petition? Contract was awarded in favor of somebody else.
Lord.
Then, now what is the challenge in a second writ petition?
Award has not been selling.
Then, what remains? Go and file a civil suit. What is where wrong is committed? You claim the damages and complaints with that liberty.
But
Don't try to keep something alive which is already dead. Already, see, count the time.
And
Already
although, my lord,
we have spent 20 seconds.
although, my lord, order order has been issued, my lord, long back.
Ah.
Progress report is 0, my lord.
So what should it? Yes, Mr. Sharma, we are not asking. Take your seat. Yes, so progress report is not there. What to
So,
be
my lord,
done? So it should be cancelled and it should be given to you in a writ jurisdiction. Time going, cost is increasing. Tell us. Answer.
lordship may grant liberty, my lord.
Hard. Mr. Ali, learned counsel for the petition. WPC 5648/2021 is filed assailing and order dated. Where is that? Assailing the decision whereby the petitioner's bid for the work protection of cutting and embankment by construction of RCC retaining wall, etc. between station Kaunpui, KAWNPUI and Sairang, 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 in connection with construction of new busy railway line from Bhairavi to Sairang within bracket Mizoram project was rejected to be non-responsive. Yes. Then subsequently, full stop. In the meantime, the contract has been awarded in favor of respondent number
4, my lord.
respondent number 4. WPC, where is the next writ petition? Give the next writ petition.
5289.
Huh? 5289 has been filed by the petitioner. Petitioner. What is the prior in this petition?
Same, my lord.
Why then same?
Different tenders,
Separate
madam.
project.
Two different tenders.
Okay. Is filed in respect of another contract, namely, it was between Swenso Ekin Silo, supply stacking, G2 pencil mark, page synopsis. To pull Imphal stations, that is Mizoram, this is Imphal. In this case also, the contract has been awarded in favor of
It was not awarded.
awarded in favor of respondent number 4. Though it is submitted that at the time of filing of the writ petition, the contract was not awarded in this case.
Private respondent in this case.
So therefore, no private action has already been awarded, not in favor of respondent number 4. You make two separate orders, awarded. And therefore, the said person in whose favor contract has been awarded is not a party respondent in the present case. Be that as it may, as the contract has already been awarded and such award is not under challenge, in the considered opinion of this court, the present writ petition is having no cause of action as on date. Full stop. Accordingly, the present writ petition stands closed. However, however, petitioner shall be at liberty to approach appropriate forum if any of his grievances still remains. There is no interim order.
No.
Mr. Sharma is present. B. Sharma is present for the respondent.
Okay.
That the petition has been blacklisted.
That is not, we will not record it, even if you say not relevant facts. We can record that if we want to enter into the merit. If you want to enter into the merit, we can, that can be a vital. Yes. Have two orders, huh? I thought it was initially same order, two contract and item. Mata, dear. No, item 3, call it. Oh, no, item 3 to be on. Give the file. This one come, please dispose of. Okay, now item 30, 36. Okay.
36, yes, madam.
Sorry, madam. Well, we have filed an affidavit, madam, in this contempt petition. Advocate General, he is appearing also in this case. The Lordship, kindly see our affidavit filed by the my lord. Respondent number 1. What happened, my lord? These parts of the petitioner land is, my lord, in the water bodies, within the water bodies, my lord, area. And when there were flood free operation was there, a certain eviction was there. Unfortunately, petitioner land was evicted and his house was demolished. And that's why what happened. So he filed this contempt petition, and now this respondent number 1, commissioner has taken the undertaking to compensate him. Kindly see the paragraph 7.
Okay, wait for some time, since petitioner is not here and there is no notice in the cause list today that we will take up the orders methods. Otherwise, yes.
Will be taken after some time, Lordship.
Yes, we'll take after.
My lord, maybe at 2, I will inform the Advocate General also.
They file an affidavit. Do you want to respond?
No, they have not filed any reply.
Do you want to respond to that affidavit?
Lordship, today matter may be taken up, my senior will.
See,
Senior 9.
see, either we take up with your senior saying that we'll decide the matter. And after that, if you say that we want to file and reply affidavit, then
For that, I have to take instruction, Lordship.
what instruction? There is an affidavit saying that this is done, we will compensate him. If you are agreeable that compensate, then what is the compensation? How is to be determined? Everything will come. So you need to file an affidavit, whether acceptable or you want him to go to jail. Of course, contempt is between us and the commission.
Lordship, then we will file.
I think so. That instruction,
They did not file it, my lord. They wanted to file it, but they did not file it.
therefore they wanted to file. Okay. A learned counsel for an affidavit has already been filed by the respondent number
1 and 3.
1. The learned, let this matter be listed on, give a date.
Lordship, any date after 2 weeks, Lordship.
Give a date.
2 weeks.
Musumi, give a date. 28th of September 2024. During this period, the petitioner may file his or her response to the affidavit in opposition filed by the respondent. Because we need to know what is your stand. That's why I'm saying, yes, next.
Deeply obliged.
Yes, Mr. Mohanto.
Yes, my lord, by order, your lordship, can you see office name that is 21/8. Laws in my order, my lord, notice is completed, my lord. Substitute, my lord.
How many respondents?
There. Respondent number 10 died, my lord. There are 3 respondents. One is minor, represented by Madam.
So respondent number 3 is a minor. So she can be represented by 10.2.
Yes.
Yes, who are you? No, nobody appears. For these respondents. No, nobody appears.
Earlier, my lord, appear in affidavit file.
Uh,
After substitution, my lord, I take steps, and this is the office note, my lord.
Lawajima Court's order dated 21/8/2024 reflects that notice upon substituted respondent number 10.1 and 10.2 has duly been served. Full stop. Respondent number 10.3 is a minor and her natural guardian is respondent number 10.1. Therefore, notice upon her served through respondent number 10.1 is accepted. Accordingly, this matter is ready as regards service.
Earlier it was in hearing, so earlier it was written, my lord.
Rule issued. Okay,
That earlier it was in hearing. In hearing, my lord, it was written.
okay. Accordingly, list this matter for hearing. When?
Next week, or anyway.
Otherwise, 2014 will come. List after 2 weeks we are giving, then it will be listed. List after 2 weeks in the hearing column.
Okay, yes, sir. हम मोबाइल टावर आप कनेक्ट करना
Tower has been established already? Huh?
Circle of sir, but is distance about the distance.
Huh?
Yes.
None appears for the petitioner on call. Why this matter is listed? None appears for the petitioner on call. List this matter in the admission column on given date next week.
Yeah.
12. Order dated 20. Yes.
Kindly after some time, my senior is on his way.
Who is your senior?
Be taken.
Next week.
No, not next week. Why? He has not taken step. Complied with.
I think so, my lord.
He must.
Yeah.
That's why he has not taken steps. None appears on 22/1.
Yes.
Steps has not been taken. Till date, no steps have been taken.
Contextual payment of no? Contextual bill. Who's a packet those things?
What is the release order?
Well, payment has been released and including the amount of security deposit. SD money has also been released, my lord. The letter of release, so my lord.
Nothing survives. Nothing survives. We are closing this. Okay, we'll close it
Let him come. On his way.
after some time. None appears for the petitioner on call. Full stop. Proceeding of Lawajima Court dated 15/9/2023 reflects that petitioner was asked to take fresh steps upon respondent number 7, 8, 10, and 11 by Lajima Court's order dated 27/6/2023 and 12/9/2023. However, office note dated 4/10/2023 reflects that such step has not yet been taken. Such step has not yet been taken till date. Accordingly, the matter is placed before this court. None appears for the petitioner on call. ISC 3000 of 23. Eighteen. 18. Order dated 9/10/2023 in ISC number 3000/2023 reflects that the learned counsel for the applicant would like to withdraw the aforesaid IA. The aforesaid IA was filed to withdraw the wakalatnama for the writ petition. Full stop. However, the said application was withdrawn on 9/10/2023 and this court granted liberty to the applicants to file a fresh application for withdrawal of wakalatnama. Office note dated 7/8/2024 also reflects that no fresh application has been filed and no steps has also been taken upon the steps has also been taken for issuance of notice upon respondent number 7, 8, 10, 11. In view of the aforesaid, the writ petition since dismissed being for non-prosecution, interim order, if any, stands vacatable. This is 40, no? Yes, the present application, IA for what?
For restoration of the WPC, it was dismissed for default.
The IA, which IA?
606.
60606, give 606. Where is the order?
Your lordship will find that page.
Your lordship can see page 8.
What was the challenge in the writ petition?
My lord,
Why award was challenged in writ petition?
my lord, that's the question I was telling my learned friend. Let it be restored. On the next day, my lord, thing will take its own course. Because I have a doubt that whether this writ petition is maintainable. My lord, under section 173, specific provision is there to file an appeal. Now, the learned counsel, why he filed writ petition? My lord, I just could
And
not.
there is now an absolute bar. Filing a
Obvious-
226, subsequent judgment.
This cannot come in any case.
Any case.
When there is a specific provision of
So,
appeal,
appeal, why
we
should that?
must fall back to that provision only.
So we'll not restore this and give the reason.
Yes, your lordship.
And my lord, only thing,
We'll just, generally in restoration petition, we cannot enter into the merit, but we'll just task it, be that as it may, because otherwise we'll restore it, it will go again, it is to be, if it's in hearing, it will go to events. Why should they suffer 2011 methods?
no, obviously, lordship can indicate that,
We'll indicate that.
yes,
We'll indicate.
that will do.
Otherwise, we'll not go, but we'll say that otherwise this is the thing.
Yes.
Heard Mr. Dr. Learned Senior Counsel on a decision application for restoration of WPC, restoration of WPC 5016/2011, which was dismissed for non-prosecution on 26/5/2017 by this court. The order dated 26/5 to Mr. Dr. Learned Counsel for the petitioner. Petitioner submits that the counsel who initially filed the petition was subsequently appointed as a member of Foreigners Tribunal on 10/8/2015 and the said counsel also did not return the brief to the insurance company. As a result, no steps were taken on 26/5/2017. Therefore, there is no fault on the part of the insurance company in such a default, and accordingly, the matter may be restored. Full stop. On the other hand, the learned counsel for the opposite party has vehemently opposed such restoration and submits that the matters pertain to the year 2011 and the order dated 26/5/2017 itself discloses the negligence on the part of the insurance company, in as much as even it is assumed that the insurance company was not intimated as a litigant, it is the responsibility of the insurance company to have a follow-up on the matter. Full stop. I have heard the learned counsel for the parties. No, the learned counsel further submits that otherwise also the writ petition is not maintainable in view of the fact that by way of filing the writ petition, the insurance company has challenged an order dated challenge and award dated 9/6/2009 passed by the learned additional district judge FTC Dorong Mongoldoy in MSC case number 131/2008 and order dated 26/11/2010 passed in Miss case number 8/2010, which are otherwise appellable orders award under section 161 173 of the MVA. I have heard the learned counsel for the parties. It is seen from the record that the petitioner insurance company was granted 7 days time to make good the deficit postal sum for service of notice on the respondent number 1 to 7 by an order dated 12/12/2011. Subsequently, on 10/2/2012, notice dated 10/2/2012 were issued and respondent number 357 had also entered appearance. However, there is no indication whether notices had been served or not on other respondents. Neither the petitioner has made any endeavor to take up the matter with the registry for listing of this writ petition. In the aforesaid backdrop, this court has dismissed the writ petition in the year 2017 when none appeared for the petition. Full stop. This court is also of the considered opinion that the insurance company, being an prudent litigant, ought to have persuaded the matter from 2011 at least 2011, though their counsel was appointed as a member foreigners tribunal in the year 2015. Full stop. Full stop. This court finds no infirmity in the region as shown in dismissing the writ petition for non-prosecution. Full stop. This court also cannot be unmindful of the fact that there is a doubt itself as regards the maintainability of the writ petition in challenging an award of a motor vehicle claims tribunal by way of writ petition when there is alternative efficacious remedy of appeal is available. Full stop. Be that as it may, this court do not find any merit in the present application. Accordingly, the same stance dismissed.
If anything is there on merit, they can file an appeal.
So, however, this order shall not debar the appellant insurance to seek the remedy available under law to them. That will definitely, will not say in this petition. 2011, sometimes you'll have to give up something. Nice. Yes, in view of the order passed in ISC 606/2021, no separate order needs to be passed in this IA 607/2020. Accordingly, same stands closed. Do take close. 7.
43.
May I please, your lordship?
Yes.
So, sir, here 2 weeks time may be given to know the status of the application filed by the petitioner, my lord.
Who are you?
My lord, A. Gayan.
No, you know you are a Gayan, but you are for whom?
For Babul Lekharu, my lord.
Huh?
For the respondent, my lord.
Who is respondent number? Where is the order?
Page
Huh? Page 9.
Relevant is page 11.
Huh? By the order dated 17/3/2021, passed in WPC 2933/2011, this court directed the respondent authorities that is board. What is the board?
Khadi and Village Industry.
Khadi and Village Industries Board to consider the representation filed by the petitioner and dispose of the same within 2 months from date of receipt of the order. Full stop. Alleging that such representation has not yet been disposed of, the present contempt petition is filed. Full stop. Mr. Munir, learned counsel, submits that he may be granted a week's time to complete his instruction whether the representation filed by the petitioner has been disposed of or not, and if the same is disposed of, he will produce a copy of the such order on the next date fixed. Full stop. Prayer is allowed. List this matter on next week. Give a date. Next week or thereafter, as per your convenience. 16th of September.
I'm deeply obliged.
44.
In this matter, this. Huh?
Yes, Kolita. What is this?
I am put a contempt law. But the interim order was subsequently vacated, lordship, subsequently modified, modified lordship.
What is the order?
Hello. Order your lordship will find it annexure to page 19, my lord.
Page
19. It was an order passed in a criminal revision application, my lord.
page.
Status quo was party the directed to maintain status quo. But the entire property, the house and the property was dismantled. And there were some signboards also.
Paragraph.
Your lordship will
Page,
find. Page 20. 20, your lordship will find. Last line, your lordship will find. Till returnable date, status quo as on today with regard to the suit premises shall be maintained. Thereafter, my lord, this interim order was extended, my lord. Your lordship will find it at page 23. In the presence of the respondents.
Okay, then.
Then, my lord, there was a house, they have dismantled. I have lodged an FIR also. Lordship will find it at page 24.
Who are you? What is the vacating order? File an affidavit. File an affidavit.
I'm pleased with it. Before the interim order was passed, the land was sold to the third party lordship, and that party has filed a vacation application. First implement petition that was allowed by this honorable, subsequently filed vacation that was lordship. I have just now handed over lordship.
When land was purchased?
Land was purchased on November 2020 lordship.
And when this status quo order was passed?
21 lordship. 12. Order was passed.
And when this when this was demolished?
That was interim order was lordship.
No, forget about that interim order. When it was demolished?
Lordship, for that lordship, the third party was because they have filed vacation application in that petition, criminal petition, lordship, wherein the interim order was passed. They are necessary party.
Who are you?
Lordship, I am the earlier owner, lordship. I am the director of that company who has sold the plot to the third party, lordship. So that party is necessary party, lordship.
When you have sold it?
Lordship, 2000, lordship, we have sold that 2011.
Have you filed any affidavit?
No, lordship.
You file it. Then also you will think who is responsible, whom order was passed. If we see that this order is not implementable by you, then it is a different issue. But there is a nexus, and if you have done all this, therefore we need your affidavit.
In fact, what will happen?
No, what has happened, we will want to know.
Let them file an affidavit. Let them
We are
file
not here to what has happened
Yes,
and
sir.
record.
Let them file an
Mr. Polita Lanet Counsel for the sole respondent. Press for and is granted 2 weeks time to file affidavit in opposition. List accordingly. Steps taken?
Steps are taken, lordship.
When taken?
On the same day, lordship,
Same
28th of August.
Okay, thus, in terms of this course order dated 28/8/2024. The petitioner has taken steps on 29/8/2024 and not on 28/8/2024.
Lordship, my instruction was Shreyas Biswas is appearing in this matter.
So There is nothing. We'll have to take it to be dismissed.
Lordship may kindly consider.
What consider? You file an application. Why you have not been able to file? Then only we cannot recall this order like this. There was a specific direction that if you take the steps during the course of the day, and if you don't take, then it will be treated as dismissed for want of steps without reference to this court. You have taken the steps next day. So registry says they have taken the steps, so we have not they have not issued the notice.
We'll file an application, Lordship.
We do not know.
Lordship may kindly consider.
What consider? We have passed that order knowing very well that you are not going to take up this matter. You are taking advantage of pendency of a review petition to have advantage in the suit. Therefore, notice was issued long back. You have not even taken steps. And you are using the review to be stumbling block for the suit not to pursue. You are filing applications under applications before the trial court that review is pending. Full stop. No steps have been taken. In view of the aforesaid, the registry has put the note that steps were not taken on 28/8/2024. Therefore, those steps have been taken, notices were not issued, as this court under its order dated 28/8/2024 has clearly observed that if no such step is taken during the course of 28/8/2024, the matter be treated as dismissed for want of steps without any further reference to this court. In view of the aforesaid, this writ petition stands to be dismissed on 28/8/2024 for want of steps. CRP not representing CRP. Dismiss. Where is the other side?
The side, my lord, I did not see here.
We'll take this matter on Thursday. Okay. None appears for the respondent and call. Accordingly, list this matter on Thursday. Thursday is give the date. 5th of September.
47.
Though notices were issued on 35/2024, office note dated 38/2024 reflects that neither ID card nor answer notice returned back for respondent number 1, 2, and 3. None appears for the petitioner on call. Full stop. Accordingly, list this matter after 2 weeks.
48 to 50.
What are these?
Lord, contempt petition, Lord, the contender number 1 has been transferred, my lord.
Okay.
So we have come for, my lord, implementing opposite party number.
What is about IA 2544?
নামটো যে ভুল গেল স্যার
25.
My lord.
অনুরাগ গোয়েল আছেন স্যার
What is this?
It was, my lord, Santanu P. Gotamare, respondent contender
No,
number
just give us IA civil 2544.
44, my lord.
What is 2544?
Same issue, my lord. 254.
No, tell us. We will have to go. We cannot write an order, same issue, so allowed.
My lord.
We want to know each and every case.
The opposite party.
2544. Let us come to first 2544.
254. My lord, the contender respondent number 1, Santanu P. Gotamare, has been transferred. And then, my lord, page 3, my lord, we have made opposite party Akash Deep
Principal Secretary, Bodoland Territorial Council, Kokrajhar, to be added as respondent number 1, my lord. In place of Santanu P. Kotamare.
Where is your statement that you have intimated this new incumbent regarding pendency of this passing of this order? And thereafter he has not done. Contempt is not a department, is an individual. You are well aware it is a quasi-criminal proceeding. So where is the notice upon this respondent saying that, see, Mr. You have just joined. This is the order pending. Please comply with this. Where is that? Don't be so casual in contempt. Nothing in your petition. You have simply said that the respondent has not complied. Who responded? It's a respondent says he must know. And you make a statement that because it's a contempt. You'll have to say that after this he has newly joined. We have given him, in spite of that he has not complied, therefore he has committed a contempt. Contempt is done by not by the office, by an individual. An individual must have a notice of the order. Where is that?
Yes, my lord. But earlier, my lord, the contemptor number 1, my lord, he filed his affidavit, my lord, in this contempt petition.
No, that is a different issue. That we'll go to. If you say that we are not pressing this application, we are closing it, we can go to that. That is a different issue.
No.
But if you say we want to implead a person in contempt, first thing has not complied with in this order. You have not intimated.
Lordship, I may be allowed to withdraw this petition with the liberty to come afresh, my lord. I'll
Mr.
comply.
Thus learned counsel for the petitioner submits that though the present application is filed implement of the present incumbent who is responsible for compliance of the order. However, prior to filing of this application, the aforesaid incumbent was not put to notice by the petitioner as regards the order in question. In view of the aforesaid, he submits that he may be allowed to withdraw this petition and to file fresh petition for implement after putting into notice after completing the aforesaid procedure. Stop. Prayer is allowed accordingly. The application I stands closed with a liberty to file a fresh petition. Stop. Same all order. Okay. Item 2544, 2545 and 2546. Contempt notice is difficult. You will have to see whether he has done a contempt.
Yes, my lord.
It will be contempt prima facie satisfaction that yes, even after notice he has not done within the period. Then only we cannot issue notices like this.
My lord.
Otherwise, Lordship, we have complied the order, Lordship.
Complied. If complied, then why should you spend all this money in filing, giving? Where is that order complied?
Lordship,
Are you aware?
Lordship, may kindly see the order, Lordship.
Where is that?
Order is at page 18, operative portion, Lord.
18 of the
Contempt petition, this is 19 of 2022. Contempt case 19 of 2022.
contempt case 19 of 2022. Here 21 and 22.
19, 21 and 22. my lord.
Here I have got 21, 22. Where is the 19? These are the
48, Lordship.
Huh?
Item 48 is 19.
Oh yes, item 19 is here. Where is that?
Page 18, Lordship.
Page 18.
Lordship, may kindly start from the word accordingly.
Hmm.
Accordingly, this petition is disposed of at the
Just a
admission
minute. It
stage.
says it with the, accordingly, yes.
Accordingly, this writ petition is disposed of at the admission stage itself with a direction to the respondent number 20 to examine the claim of the petitioner as regards entitlement of the petitioner for the bill amount of so and so in response to execution of the contract number under reference number. And if such examination and verification the petitioner is found entitled, then any balance amount, then the respondent BTC authority would process the claim of the petitioner in accordance with terms earlier.
Yes.
Lordship, we have prepared the list, Lordship. Its name is already, it is under process, Lordship.
Okay, Tomseral is a difficult proposition. Anyway, we'll not close on that. Let us wait for something. See, therefore, if you put a notice to him and he says, yes, we have complied with this is the list we'll give you in seriatim. That's why a notice is required. You give a reply to him when he gives a notice. Tomseral is the difficult proposition.
my lord.
We cannot
Yes.
quote her because the law itself says that they will have to give seriatim. We cannot say they give him not to them until and unless we
Yes,
pass
sir,
a
but-
special order.
But my problem would be Lord,
But-
following Tomseral, you have already prepared a list.
List. You will
Some
have give,
persons are above him, Lord.
that's it.
Without paying them, we cannot pay him. That
The
would be
amount is, my lord, allotted at the time of, my lord, the allotment of.
But
the-
you have agreed with Tomseral.
My
You
lord,
ought
that
not to have
is-
agreed with Tomseral. You would have argued that no, Tomseral is not applicable because of the FRBM Act and my project is saying I have a separate sanction amount. So therefore, I will not come under Tomseral. Everybody accepts Tomseral. If Tomseral is accepted, you'll have to go on seriatim. What can we do? That order is already there. When there is a specific finance earmark for a project under FRBM Act, which is came into after Tomseral, then you will have a right over that until if they admit. But you have accepted Tomseral.
My lord,
Seek a review of that order. That's all.
yes, my lord.
We cannot have a.
Deeply obliged.
So this is a very easy way out. Lordship will dispose of Tomseral. Now you face this problem.
It was, but anyways, my lord, deeply obliged.
Herein, your lordship, the name of the petitioner was wrongly written in the read petition as Nilima Gogoi, but her actual name is Nilima Gogoi, your lordship.
What I'm not getting it. Her name is?
Her name, actual name is Nilima Gogoi, but it was written as Nilima Gogoi.
Where?
In the read petition, your lordship, in the cost title. And
Now
that
what is to be done?
Yes.
in that read petition has final order part.
No, they have seen there.
The final, I'm saying that, your lordship. The final, that read
We
petition-
understand. You need not explain so much. There was a writ petition file. In the writ petition, the petitioner declared her name to be
Nilima Gogoi.
Nilima Gogoi. Who signed the affidavit?
But in affidavit.
Let us, and you answer this question. Who filed the affidavit in the writ petition? Nilima or Lilima?
Lilima.
What was the name was declared?
In the affidavit, your lordship, in her signature, she was written as Nilima Gogoi.
Nilima.
Correct name.
Correct.
It was fault on the part of us, your lordship.
Okay, understand. That's why I'm asking. She signed as Nilima, but according to you, it was the fault of the lawyer that it was written as Nilima. So therefore, her name should be read as Nilima Gogoi. Now, what is the order? What is the direction issued?
Page 18, your lordship, kindly. In page 18, para 7.
How you are related to Profullo?
Profullo is the husband, your lordship. He was the husband. And I have given all documents, your lordship, here in this petition. Page 20.
Hard. Learned counsel for the petitioner. The present application is filed in a peculiar circumstance. Full stop. The applicant, namely Lilima Gogoi, is that it? Lilima Gogoi preferred Lilima Gogoi, wife of
late Profullo Gogoi.
Wife of, don't commit mistake now. Wife of late Profullo Gogoi filed a connected writ petition seeking ex gratia compensation on date of her husband. Is that it?
Yes.
Husband, that is Profullo Gogoi, for on road MB Act or
No.
extremist.
Extremist.
Gogoi, who was killed by extremists. Full stop. The though said Lilima Gogoi put her signature in the connected affidavit as Lilima Gogoi. However, her name was incorrectly typed by the learned counsel for the petitioner while drafting the petition in the cost title as well as in the affidavit as Nilima Gogoi, Srimati Nilima Gogoi. And accordingly, when the writ petition was disposed of by its order dated 28/2/2023, the name of the petitioner, name of the applicant was also recorded as Nilima Gogoi instead of Lilima Gogoi. First off, it is submitted by the learned counsel for the petitioner for the aforesaid is submitted by the petitioner that the aforesaid mistake committed by the counsel for the petitioner is now creating a stumbling block for implementation of the order dated 28/8/2023, whereby the additional ex gratia amount of rupees 2 lakh was directed to be deposited in the account of the debt in her account. Full stop. How do you know that this is the same applicant? Where is your statement?
Yes, 21 years.
Huh?
Yes, 21 legal year.
Legal certificate was in the writ petition?
No.
Was it a part?
But the Gaubra certificate was the part of the petition. At least 20 years.
The petition as of 21, but this next of kin certificate is of 20, but it was not in the.
Can you do one thing?
Not sure.
Can you make a verification?
Sure.
See,
Lordship, yes.
husband is died.
That is correct, my lord. Because
Husband is died. If it's a genuine case, let us have a satisfaction. In the aforesaid backdrop, MSU thus learned counsel submits that she will complete her instruction from the concerned deputy commissioner,
my lord.
whether the actual name of the petitioner, actual name of the claimant, that is wife of late Prafulla Gogoi, actual name of the wife of late Prafulla Gogoi, and also to verify whether the present petitioner is the wife of present applicant is the wife of late Prafulla Gogoi. Full stop. In view of the aforesaid, the matter stands adjourned and be listed after
3 weeks.
3 weeks. Full stop. In the meantime, the instruction may be obtained by the learned counsel. Full stop. And the deputy commissioner may complete his instruction through a local inquiry done by the local revenue circle or through the Gaon Bura of the area in sending such
Lordship.
report if so advised.
Lordship.
Yes? No date. These are your mistakes. All blank paper signed, then print out in the affidavit. Over telephone, whether Nilima or Lilema, somebody will send a brief. Even you are not aware who is the client through the brokers. We know all these things. And who is the actual beneficiary, they will not get anything.
58.
Yes, Mr. Bhattacharya, what is this?
Lordship, in this case, your lordship, I have talked with the concerned officials of the bank, your lordship. They said that they don't have any information on this. They need some more time.
Okay.
They could not trace out the file in their branch, and so far as the appeal is concerned, what happened to that appeal? Appeal probably was transferred to Allahabad.
Okay.
They contacted Kolkata lawyers. They said that it will have to be inquired in Allahabad. Therefore, they need some time.
Mr. Bhattacharya, learned counsel.
Petitioner is here. She may have some idea about it.
Yes.
Contact with the client. We are also praying for some time.
I think nothing survived, it seems. But still, it's a valuable right. We cannot shy away. Mr. Bhattacharya, learned counsel for the petitioner, as well as MS.
I does.
I dash learned counsel for the, no, for respondent number, respondent bank, and MS I dash for learned counsel for the petitioner. 6 for an adjournment to ascertain whether any live cause of action is there in the present petition. Full stop. Prayer is allowed, list this matter after 3 weeks. Roughly.
Please, Lordship, my lord, steps regarding 516. 5 is already transferred out, my lord, so there is no grievance against him now.
There no grievance.
Now, he has been transferred out. He was creating some problem, my lord, he has been transferred out from Thelamara, a circle officer. So his name is Mr. So for 6 is concerned, my lord, the address was given correctly, but the
What is this case, Mr.?
regarding, my lord, it is a private land.
Hmm.
So circle officer issued notice for eviction as the people's government land.
No.
So we challenge it.
Then there is a stay.
Huh?
There is a stay.
Yes. So, my lord, now for this man, my lord, we may have to take fresh step. For this man, 6 will take fresh step.
Respondent number 6. What is the who file affidavit? Yes, who is respondent number 3? Officer, state respondents. What is the stand? Maybe annual Pattalan, maybe, but if annual Pattalan, there is some right.
Yes, madam. In paragraph 5, my lord, we have stated that the petitioner is not recorded as landholder in the official revenue record.
However,
under Thelamara Revenue Circle. Further, as the transfer was illegal and violation of rules, it was never mutated in his name.
okay, we understand. Who is for the now steps is to be taken upon whom, Mr.
6.
It is submitted by Mr. Sharma, learned senior counsel, that the respondent number 5 is not necessary.
No.
Huh? Submitted that for the determination of the present dispute, the respondent number 5 may not be a necessary party. Therefore, his name may be deleted from the array of parties. Full stop. Without entering into, just listen to me, and without entering into merit of such claim, the name of the respondent number 5 be deleted from the array of parties with the risk of the petitioner. Full stop. Mr. Sharma further submits that he may be granted how much time? 5 days time to take fresh steps upon respondent number 6. Prayer is allowed.
By next Monday.
5 days.
Certain fresh address.
7 days. 7 days time. Okay. List this matter after 4 weeks with updated office note on service. Interim order pass earlier shall continue till the next date of listing. Mr. Swami, let us do after we finish up the matter. Ultimately, this is a hearing matter. Okay, after admissions are completed, we'll come back to your case.
Yes, I have no problem.
Yes. We'll complete this matter. Though it is in IA, because it is listed in IA, matter has come, we'll therefore. Yes. Yes.
Applicant has received the amount. So
Item?
Item 39, right?
You have received?
Yes.
So nothing survives.
Nothing survives.
The learned counsel for the petitioner submits that order in question has already been complied with. Full stop. In Mr. Das is present representing the respondent number
123.
All the respondents. Full stop. He has also produced communication to suggest that the order has been complied with, which order dated 23rd of December 2020. Has produced an order to suggest that the order has been complied with. Full stop. Considering the matter in accordingly, the contempt petition stands closed. Full stop. The order dated 23rd of December 2020 is kept on record. Give this. I will keep only that
Yes, yes.
one. And marked as document X.
All right.
I'm sorry for the interruption. Item 45, my lord, we have taken steps on the same day, my lord. My clerk is standing behind, my lord.
Okay, fine. So therefore, make that statements. We'll pass an order saying that you will file an affidavit to that effect.
Yes, your lordship has.
I will pass that. Pass that order. That is what we are expecting. Your junior said they are a serious matter. You have sent him. So he says that we have taken on. He has not disputed. So we file an affidavit.
May not.
Though, which was the item? Which was the item?
45.
45. Though office note reflects that steps was taken on 29th of August 2024, the learned counsel for the petitioner submits that steps has been taken on 28/8/2024 in terms of this court's order dated 28/8/2024. Full stop. As there is a dispute as regards service, let the petitioner file an affidavit with along with the proof thereof to show that steps were taken on 28/8/2024.
But only the tickets were submitted next day because it was not available with the vendor.
But you have taken as steps. There must be some talavana. There must be some seal.
It's not available, my lord. This is
Why?
not a predicament, my lord.
Why
Because
not
as
available?
per the statement of my clerk, my lord, when he went for collecting the my lord, tickets, the tickets were not available. That's why tickets were submitted on the next day.
File an affidavit.
Yes.
Proof to not like file an affidavit. We'll file an affidavit.
Much obliged, my lord.
See, we are serious in all these matters. We do not. We are very serious.
Much obliged.
Let me start করি না করা 12 বার তো
There is a affidavit to be filed by revenue, my lord, 38/2019.
Where is the revenue?
For the land acquisition proceeding without taking the.
Yes, revenue.
Lordship, in this matter, we have communicated the honorable court's order with the department. And also, your lordship, on several occasions, several reminders have also been sent to the department. Still, we are waiting our instruction to lordship.
Who will be the responsible officer?
We have
To
received,
whom you have written this?
we have received an instruction, pairwise comments, but then I don't think this will be sufficient. Lordship, kindly have a look.
Okay, just listen to us. Who is that order?
38/2019. Land.
Now, what about the suit?
Suit actually, what happened, my lord, the land was, he is the owner of the 15 acres of land and some government land is there.
No,
In
that we
2004.
understand. See, Mr. Borua, there are some difficulties. During the pendency of this writ petition, you file a suit, or prior to that, you have filed a suit.
Money suits.
Money suit.
Yes.
Seeking compensation
Yes.
and declaration that seeking compensation on the ground that your land has wrongly been, your building has wrongly been demolished. It is a patta land. Isn't it? That suit has been dismissed.
That it is a land.
Listen to us. Suit has been dismissed. There may be many defects in that decree. We see many defects in that decree. Till now, I can say there are 5 issues. Issue number 5 is not even discussed, which was the vital issue. 2 pages, a decree has been passed. That we can take judicial notice, we can take action, that is a different issue. But a decree is passed, dismissing your whole claim, which is the subject matter of this writ petition. Did you prefer any writ, first appeal?
No.
Then what can we do?
Here, my lord, this court, lower court has observed that land is not acquired by government. And in inquiry report says that there should be a LA proceeding. So a land was taken by government without going through. That is his fundamental rights has been violated.
Why have you filed a suit? You have already agitated your fundamental right. In a suit, there is a decree in favor of the government. Can we reverse that decree in favor of the government?
Not government, my lord, that the executive engineer has.
That is the, you are seeking,
Now they.
ultimately, according to the requiring, they have not said we have acquired. Yes, madam, have your instruction. We are not saying anything.
Yes,
You just intimate whatsoever.
yes, sir.
If they are not coming with instruction, this is a matter of 2016, Commissioner and Secretary will be present. Full stop. Where is that order seeking?
38, 2019, my lord. The activities that
This court, by earlier order dated 38, 2019, taking note of the controversy, has directed the Revenue Department to file an opposition answering the following issues. A, whether petitioner is possessing land covered by the periodic patta, and if at all the land is required for larger public benefit of the locality, whether there is any acquisition process initiated or proposed to be initiated. C, the present status of the land on the possession of the petitioner, including the extent of area under his possession. Full stop. Though such order was passed in 2019, no affidavit has been filed by the Revenue Department. Full stop. MS, you are? And Bodoloi, Learned Standing Counsel for the Revenue Department, submits that they have written umpteen number of communication letters to the competent respondent authorities to give them the instruction. And though an instruction has been granted, however, such instruction do not answer the queries raised by this court under its order dated 38/2019. Therefore, she prays for adjournment as a last chance to complete her instruction and file the affidavit by the next date fixed. Full stop. Though this matter is pending since 2016, considering her submission, the prayer stands allowed. List this matter on. Give a date after 2 weeks. 23rd of September 2024. The affidavit be filed by 28th of September 2024, incorporating the instruction sought by this court under its order dated 38/2019. Full stop. If no such affidavit is filed by 28th of September 2024, the Commissioner and Secretary, Principal Secretary of the Revenue and Disaster Management Department shall personally remain present before this court on, what is the date? Next date? 23rd of September 2024 to explain the queries as raised by this court under its order dated 38/2019.
More time.
What more time? 2,000? No.
One more week, you know.
Let us see.
Bless
We
you.
have to have enough.
Have that document on also. Bless you. I can see.
Yes.
Yeah.
Hmm.
In this case, your lordship, land has been acquired in the
No,
year.
what is their stand?
Their stand is negative, your lordship.
What they say?
They have said, your lordship, see the page.
You will not see, tell us. We want to hear, not read. Yes, tell us. What is their stand?
No, there. I am reading them. Claim
I
of
can also
petition
read.
is
Tell us,
completely
summarize
denied.
this. Huh?
Completely denied.
No, see, issue is having an award has been passed, isn't it?
Yes, yes.
Now, by the award, it was reverted back to the Deputy Commissioner,
Yes.
isn't it? That
No,
consider
yes.
consider the
Consider the case of the petitioner.
consider payment of interest and solicium.
Yes. Solicium and interest and the building value.
And the building value.
Yes.
And
Huh?
only building value.
Building value.
Not the building.
Okay, now have it paid.
No,
not paid.
Lordship, actually, there should be some joint verification.
Hmm.
They have done it by the executive engineer PWD. And they have informed us on only
No, why this land was not given, building was not given, you have demolished it.
already compensation has been paid, Lordship.
Now,
They have approached the arbitrator.
arbitrator said that you have a reassessment.
Yes.
Reassessment where? Building is already demolished. Now, how will you do a,
Before demolition, there is a report.
who have done this report, reassessment report, huh?
PWD.
On whose request? The earlier assessment was also done by the PWD.
Yes, but on the basis of the rate of 2004 and 5. But the
Okay.
land is acquired in the year 2010.
So you want to say the assessment is fine, but rate should be of 2011.
2010.
Assessment was of 2004-5, Lordship.
2004.
When it was acquired?
It was acquired in 2004-5, Lordship.
When it was demolished?
Demolished, I have
2011.
no idea when it was demolished.
So if demolished 2011, when the land was acquired, the property vested in central government.
Central government,
So where is the question of giving you enhanced rate at 2011?
11. But
No.
as per section 3A, the land should be valued as per on the date of the publication of 3A.
So if you claim that you are entitled, you have went to the arbitrator.
Yes.
Arbitrator ought to have decided.
He has not decided.
What is the decision? Arbitrator said you go back to the deputy commissioner.
Deputy
How deputy, once deputy commissioner has passed an order,
No, not passed. Still that it is not. passed.
initial award was there.
Yes,
Initial
that has been enhanced.
enhanced by whom?
Arbitrator.
So have you paid the enhanced?
No.
There is no such
No,
order.
there was enhancement, but so where is the award? Give us the arbitrator's award.
Yes, page 34 of their institution.
Huh?
Page 34 of their institution.
Fixing the valuation of land, the solicium and other considerations shall be
Just a minute,
included.
just a minute.
One, two. First piece.
So, see, taking possession of the land by the competent authority. Taking
Yes.
possession is,
Possession in the year 2010.
what is the notification says? Actual possession will,
2005.
huh?
2005.
What is the notification says?
Notification he is not annexed.
When payment was made? See, there is some legal fiction. It is not like that somebody has taken a land, possession is not taken over because therefore possession will mean at a future date.
No, it is taken in the year 2010.
No, that we understand. What is the legal fiction? Suppose in under 1894, when a notice is issued under section 4, section 6, moment section 6 notice is issued, it faced in the faced in the government. In the Highways Act also, there are certain provision which says it will be faced when the payment was made. Because possession cannot be taken without payment under Highways Act. So for 1894, it is different. So if payment was made, notification under section, I forgot that number of the section, then it is to be deemed to be possession of the National Highway authorities on that day. Therefore, actual possession will have no relevance. These are prima facie. Now, so far coming to solicium. Solicium, there is a question of
Limitation is there, Lordship, because it is 2005 notification. The
what
solicium also,
limitation is there?
because interest there should be Ministry of Highway Lordship, there is some notification regarding
Notification regarding what?
regarding awarding of interest and solution. So at present, I don't have the notification.
There is a
but-
provision in Acquisition Act also.
No, madam, we are not getting the point.
No,
Is
in
it a mandate to pay solicium under the act? There is a mandate of payment of solicium under the new act, is not it? It is there. So why, if it is not paid, will you go by the technicalities?
Lordship, what happened, the arbitrator, he has not directly said that payment, solution and interest should be paid. No direction. The direction while fixing the valuation of the land, the solution and other considerations shall be included as per direction of the state government. The state government has not directed.
What
to pay
state,
solution.
forget about the state government, you are under bounden duty to pay a compensation in
Yes.
terms of the act. Act itself says there should be solicium at the 100% rate or this rate.
No,
Have
later
you
on,
paid that?
So 100% solution was included later, Lordship, in the year, I think 2011, after that they will get.
We'll have to see.
That I have to take a document that.
This matter is having
Because it's a old
importance.
cases, there is no award of any 100% solution. Recent cases.
You say that there was an amendment in 2013 Act incorporating the 100% solicium?
No, that is not there, Lordship, but earlier it was the.
No, no. Will you will be bound by your notification or by the Act of Parliament?
It's in the Act, Lordship, Highway
Then
Act.
what the Act says, is there any amendment incorporating solicium at subsequent point of time?
Lordship, in the 3J.
Yes, they last, what is 3J?
Land Acquisition Act 1 of 1894 not to apply. Nothing in the Land Acquisition Act 1894 say apply in an acquisition under this act.
Understand?
That
We are
land
not
acquisition-
saying we are giving him benefit under
Land acquisition.
land acquisition.
But in the Highway Act, Lordship, there is no mention of. the
But
solution.
there was a not applicability is relatable again to 2013. There is a provision in 2013 in the schedule which act will not be applicable and for what
Yes.
period?
2013, this is the old
Then-
case, the 2005 matter, Lordship.
There are some period, what have you issued notification thereafter excluded? You issuing notification will not do, it is to be issued by the union in exercise of power under the 2013 Act.
Moreover, in his prayer also, there is no such, no such prayer regarding payment of interest and solution. Only building, his made pray for adequate compensation.
We will go to all this, all
for,
technicalities later on.
yes,
You please
yes,
get clear,
yes.
say clear yourself.
Lordship.
What is the provisions of law? If you are clear, we are proceeding in this matter for final disposal.
Yes, Lordship, I have to get.
You are ready?
Instruction. No, today I am not ready. I have to take instruction.
On the prayer of the learned council for the national highways.
National Highways.
Matter stands adjourned and be listed on give after 4 weeks. We will take up this matter.
Fine, instruction.
3rd of October.
3rd of October.
Okay.
Yeah, Baba, you do not.
We are not happy. See, we are not expert to comment on this. Is it a way to write a report? Huh? Is it his statutory responsibility? That's why we are keeping this method.
There is
This
a
is not the
provision
way.
for appeal, my lords, in the act
So
itself.
that we understand.
Yes.
But we want that this is a huge responsibility. Many questions are to, in retext jurisdiction, we will ask many questions to this person. He says that he has touched the maybe where or what, so what.
Overhead connection.
Overhead connection. Hand is clear. No burn in his hand. Absolutely no. I think they should file an affidavit. I will ask many questions. We may seek a medical report. This is not the way dealing with person's right. He is having a statutory responsibility.
Yes.
We cannot shy away from this kind of report. Can he write a report like this? Reason is so and so. Violation of 64. What is 64? How he has violated? One page is a report dealing with a life and liberty of a person. On the prayer of the learned counsel for the petitioner, matter states adjourned to enable him to file a reply affidavit to the affidavit in opposition filed by the electrical inspector.
But in the meantime, then we'll also file our affidavit.
In the meantime, APDCL may also file their
Deeply.
after 3 weeks.
May I please, we are not raising this petition.
Okay, learned counsel for the petitioner submits that he, Mr. M. Ahmed, learned counsel for the petitioner submits that he has instruction not to press this petition accordingly. You are
I'm for Agriculture Department, Standing
the
Council.
learned standing counsel, MS
Zibora.
G. Bora is present for the respondent agricultural department. So, in view of the submission made by the learned counsel for the petitioner, matter stands closed, being not pressed.
Okay. May I please, Your Lordship? Lordship, kindly pass out for a day. My senior is out of this one.
What is the issue here?
Regarding an agency lordship.
There are two brothers and some disputes. Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 2 weeks.
Your Lordship.
May it please your lordship.
Mm.
Lordship, the matter pertains to capital subsidy, lordship. Now, I had made an application before the authorities for giving me capital subsidy. Now, they have rejected my capital subsidy claim in SLC meeting, lordship. But my prayer, my argument is, lordship, my submission is that this, what they have contemplated in their affidavit, that this can be for such and such reason, it may be cancelled. That is not correct, lordship, because neither the policy nor the notification implementing the policy has set such conditions. If I may take your lordships to the policy, lordship, capital subsidy
What is the
policy.
policy? You are ready, Mr. Kolita?
Yes, yes, yes.
What is the-
Lordship, actually, what has happened is that there are certain similar matters were there. But unfortunately, Lordship, yesterday I didn't get much time. So similar cases were there wherein actually what has happened is that they have gone for substantial expansion. They have invested some money. Then actually there was a notification from the central government that they need to disclose like how much electricity they have consumed, what is the VAT they have paid, excise duty, VAT, whatever they have paid. And on the basis of that assessment, they will give the subsidy, whether it will be rejected or given, because they need to basically show that like they have done some substantial expansion and their production has increased. So if the production has gone down, so
Then
that
only for
correct.
This is incentive.
Correct. So
Scheme is itself is incentive that if you have done this much,
correct.
you will get the benefit.
Correct.
Okay.
So with that, so now what has happened is that like in the policy is silent about this. That is correct. My learned friend is correctly said the policy is silent about this, but there was a notification from the central government later on. But that also clearly doesn't say that you need to,
Yes, that
if just a moment, if it is, I mean, like the production is going down, then you reject it. That hasn't been said, I mean, clearly. But the purpose of giving notification is that.
We want to say that the object of the policy to give incentive to the organizations who are actually in the field and they are made substantial investment.
Correct, correct.
Now, according to you, policies does not specifically disclose it.
Disclose this.
And therefore, you will have to satisfy that though it is not disclosed, this is the actual policy
Correct.
from your conduct
Correct.
or your behavior.
Correct.
Otherwise, they will argue that it is our rejection is something which is not included in the policies. This is the issue.
Correct, this is it. So
Now,
Lordship-
should we go for disposal
no,
or
no.
there are some other matters you want to do it some
No,
other day?
Lordship, some other matters were there. In the other matters were also sent back to the department for reconsideration, and some matters have been already reconsidered.
And allowed.
Probably they have received the money also.
Yes.
So
it
only
has been-
thing is that, Lordship, I don't have that particular order today with me. I'm extremely
Are
sorry.
you
Lordship.
having?
If they have it, they can place it, Lordship.
Okay, we are taking up next Thursday.
Next Thursday, Lordship. I'll place the order similar cases. Lordship.
It is submitted by Mr. Kalita, learned Standing Counsel for the Industries and Commerce Department, that in the similar background facts, some orders has been passed by the coordinate bench relegating the petitioners to the department so as to consider their claim for capital investment
Central capital investment.
central
subsidy.
capital investment subsidy. And according to him, if there is no objection of the petitioners, the present writ petition can also be disposed of in terms of the aforesaid orders. However, he is not in possession of such order today. Accordingly, he prays for an adjournment. Full stop. Prayer stands adjourned. Please this matter
On 13th.
on
13th.
day after tomorrow.
No,
13th.
13th.
13th of possible. 13th. 13th
I don't
of
have any issues, yes.
13th of you are aspect number 4. In view of the aforesaid, let this matter be listed on 13th of September 2024. Any other matter so that we can pass in it? Not necessary.
12 also similar.
Huh?
11,
Okay.
12.
11, 12 together, huh? This is common order.
Common.
Much okay.
On last occasion, Government Advocate has submitted that FIR has been filed. Lordship, we need some time, 10 days time to ascertain because Lordship, the client has not received any notice, Lordship.
Client will not receive any notice.
In this case, this is a serious matter whether wherein the one Rangana Burua has sold the property of the my client, Lordship petitioners, but with a forced signature, Lordship, and thereafter pursuant to filing of this writ petition, the said Rangana Burua was arrested. Okay, we fix the matter next week. Any date, Lordship?
No. You are the informant.
Yes, Lordship, because
You are the informant. The FR is filed. Now the magistrate will issue a notice to you for objection. You file an objection here. Yes, the details are there. I am recording it. You find and verify. What is your prayer in this writ petition?
was an investigation because pursuant to filing of this writ petition, the accused was arrested. Lordship.
Election.
The present writ petition is filed by the informant in which case? Informant in
357 17.
Dispute police station case.
Dispur PS case number
3570
3570/17 registered under
120B
section 120B
420
420
406
406
468
471
IPC.
471 IPC. The prayer made in this writ petition is for a writ of is for a direction to the state respondents to cause an honest, prompt and efficient investigation of the matter and a direction to the respondent authorities to submit the charge sheet as per section 173 (2) of the Code of Criminal Procedure 1973 at the earliest. The learned State Council has obtained an instruction from the Deputy Commissioner of Police (Crime) Assam, Guwahati, status report, obtained status report, crime Guwahati, which shows that after completion of the investigation, the case has been returned in FR by Dispur PS FR number 6326/23 dated 30/12/2023 by the IO Sri Jishnu Janakya Gogoi, and the original case diary along with the related documents has already been sent to the jurisdictional magistrate. In view of the aforesaid and in the backdrop of the prayer made in the considered opinion of this court, nothing survives in this petition to be adjudicated. Accordingly, the writ petition stands closed. However, petitioner shall be at liberty to agitate his grievance against such FR, FR filed before the learned jurisdictional medical as per law.
Hello.
A copy of the status report is kept on record.
Item 15.
The last time was granted to file affidavit in Islam.
Yeah, maybe the logic required 3 weeks time, my lord. Last week of September, I'll take instruction or either file affidavit.
Okay, MS Gayan, learned CGSC, request for further 3 weeks time to
yes, sir.
file affidavit in opposition. Prayer is not opposed by the learned counsel for the petitioner. Accordingly, same stance allowed. List accordingly.
Made pleasure lordship. My lord, petitioner husband was expired.
Yes, who
in
is
the custody of
representing the
state.
state?
My lord, they had filed affidavit, my lord. And in the affidavit, my lord,
What is the forensic that report says?
report says, my lord, he was suffering from tuberculosis, my lord. But he was arrested on 2/7.
No, that we understand. See,
Yes.
in the postmortem report,
Yes.
it was said that cause of death cannot be disclosed till the forensic report has come. Now, forensic report has come. What is the opinion now?
Opinion, my lord, in page 28, running page, my lord,
Page
28, affidavit filed by the respondent,
page 28.
annexure 10, my lord.
By the postmortem.
Yes, my lord.
Annexure 28 is the FIR copy.
My lord,
Affidavit filed by
filed by the respondent number 2, my lord.
respondent number 2. Annexure
Annexure 10, my lord.
Annexure 10. Okay, now this is the postmortem report. Yes, where is the
That death was due to pulmonary tuberculosis.
where do you get that? Which page?
My lord, page, my lord, maybe it's 30 and 28.
28. Okay. No, see, this is the report. Postmortem report, is not it?
Postmortem.
At last, assistant surgeon, it says the opinion regarding cause of death has been kept pending till receipt of toxicological analysis report from DFSL Kahilipara. What happened thereafter?
Thereafter, my lord,
Where is that toxicological report?
that I don't have, my lord.
No, they have not annexed.
No, my lord.
That
only
is what
this-
we want to know. Where is that report? See, simple thing. Here, there is no injury. They have said that on this basis we will not opine. Now, toxicological report is said. Now, we want to have the opinion of there must be a final opinion.
Man, I'll procure.
You go to continuous page 84 of your affidavit.
Annexure 10.
After the postmortem, the assistant surgeon plus assistant surgeon opine as to the cause of the death, that opinion regarding within inverted comma opinion regarding the cause of death has been kept pending till receipt of toxicological analysis report from DFSL Kahilipara. However, the affidavit filed by the affidavit file at where is that?
My lord, lordship may kindly have a look at page 30 of our affidavit.
Your page 30 is the opinion.
Opinion.
And 31 is the medical legal. This is Human Rights Commission.
Human Rights.
Human Rights Commission has written Therefore, now this court is, therefore, the state respondent shall obtain instruction. Because it is the toxical report, it says that no poison was found.
No poison was found.
But your Xerox was so careless that it comes with a head note paid of the Assam Human Rights Commission. Whether this
No,
is a
no,
human.
it is not that. At page 30, Your Lordship, you'll
Huh?
find page 30 of our affidavit.
Yes, page, where is that? Page 30 is the last page, page 5 of the postmortem report. Next order is the toxicological report by the medical officer, Department of Medicine, Guwahati Medical College. Is not it?
Human rights.
Okay. Subsequent, this is the difficult. Subsequently, no, what is to be done now?
Lord, we want an independent inquiry, my lord. Regarding, my lord, he was arrested, my lord, that BIO.
We are not against giving an independent inquiry, but we must have some satisfaction on regarding the exercise of power by these independent forensic authorities and the postmortem.
Because, my lord, he was arrested on, my lord.
No, that we know. He was arrested, he was healthy, he
Yes.
was in hospital, he was died.
Yes, my lord.
We-
At least, my lord, medical assistance, my lord. At least one X-ray could have been done by the respondent number 3, my lord.
That is an aspect of the matter which relates to giving you a compensation.
Yes.
Isn't it? Your case can be when a person dies under the custody of a state, even if it is a natural death, if he has not been treated properly, then you are entitled for a compensation, no doubt about it. But we'll have to have a doubt on the what is the relation with the report. Suppose assuming it's a pulmonary death, then also you are entitled for compensation, what you have argued. Isn't it? Then to give an investigation, we must have a satisfaction that this investigation was not properly done. But we are not having that satisfaction on the basis of this record. We are more or less think that there is no bias or any influence on the forensics and doctors.
My lord, yes, my lord, but my lord, he have several times he have asked for medical help, my lord, but they have not sent him to GMCA's hospital, my lord. And my lord, petitioner also several times requested before the jail authorities to give him proper checkup.
Where do we say all this? From where?
My writ petition, my lord.
Your statement?
Yes, my lord.
By
the petitioner.
petitioner.
Yes, my lord.
Your knowledge from where have you got this knowledge that your husband was asking for help?
My lord, because when I visited my lord jail, then he have informed me, my lord, informed to the petitioner that he have chest pain and abdomen pain.
And at that time, what did you do immediately?
And my lord, immediately after that, my lord, I have requested before the jail authorities to give him.
Anything is there written?
No, no.
How they have responded to all your statement in their affidavit?
My lord, they have stated that they have give attendance, my lord. They
That you have intimated them all these are there.
intimated not by through letter, my lord.
No, not through letter. That you have verbally intimated. You have made statements in the affidavit. How they have responded to it?
My lord, they have stated that on several occasions they have treated. But this treatment, my lord, what they have prescribed for, my lord, medicine, my lord, these medicines are only for painkillers, my lord.
We have seen that.
Yes.
3-4 days. For that, what kind of inquiry you are seeking?
My lord, but that time, my lord, when he was treated.
I understand.
Yes.
Suppose we are prima facie satisfied that proper treatment is not given.
Yes, my lord.
Now, what kind of inquiry you are seeking? By whom?
Because, my lord,
by whom?
By whom? By CBI, my lord.
CBI can do inquiry when the investigation is not properly done. You are not getting the point. We are not having any doubt on the inquiry. We are not having any doubt on the inquiry. So therefore, we will not give a fresh inquiry. For so far relating to any criminal, because it's an SRL debt. It is an SRL debt. So we are not giving. So
was
you
involved in crores of rupees, my lord, scam, my lord. That is why we have some foul play, maybe part, my lord. That is why we need, my lord, an inquiry. My lord.
this is not a case for CBI inquiry. We must have some doubt upon the integrity. Must have a doubt upon the conduct of this authority. Otherwise, it's not easier that it's only seeking. You'll have to satisfy. From the report, what we have seen is that investigation is properly done. Death is a cause of natural death, prima facie. Of course, you can very well argue, law is well settled, that when it is not always necessary that he should die out of torture in custody. It is the state's responsibility to give him proper medical attendance. If that has not been given, he died out of that. Of course, you are entitled for exit. What is your case? You want a CBI inquiry, then you are dismissing it right now. And if you say that your case is not that, I want a compensation, and there is a fault on their part, which prima facie shows that proper treatment was not given, we can consider that. We cannot say that we will allow your petition. We can consider that. But where are those pleadings will be required? Where are those?
My lord, I have written in my writ petition, my lord.
You have written. So therefore, that part, yes, Mr.
Explain how we have, he was under the observation of jail doctor for so many days.
But we have
And
seen the jail doctor has given him only painkiller.
that
And whether he was a tuberculosis patient, tuberculosis to dead. If we go by the report of tuberculosis of a person dying of a tuberculosis at this stage of development, then of course it is a fault on your part.
my lord, tuberculosis are of different types, my lord. This is probably the
We do not know.
Some
We do not know.
neurological.
Therefore, we want an inquiry. If your doctor cannot identify a tuberculosis patient for days, he was hospitalized. It is a failure on the part of the state. A human life is gone. Your argument should be in that line. You are asking CBI, what CBI will you do? We are not here to you to advise here. We are here to decide.
Only for, my lord, compensation, my lord.
Come prepared. Come prepared with case laws and all. And you'll have to establish prima facie to our satisfaction that yes, this is act where this person's life could have been saved. Then we may give a direction of inquiry by a district judge only to look into whether there was any negligence in custody. That's all. You get the point? Or if you are insisting on CBI, then we can
No,
right
my
now
lord.
dictate
No,
this
my
order.
lord. On next date, my lord, I will.
Yes. On the prayer of the learned counsel for the petitioner, matters stands adjourned and be listed on October,
Oblige me.
4th of October.
Sir, I supposed to file affidavit in this case, lordship. I have got the instruction.
Take your lordship, last order passed by your lordship kindly, sir. 23,
it.
5/2023. That
Give
day
us
also
time
my
to
friend.
counter. File this, file this.
Lordship, I am filing.
Otherwise, we could have disposed it of, but since this matter relates to board decry. Board decry is difficult.
We are disputing, lordship, that is.
Board decry is.
But they dispute, they have paid 36 lakhs.
No, that we understand. We have already
Yes,
passed,
but
we have
they have
already passed an order so far because board decry is a difficult proposition.
In that event, my lord, I have a direction to approve the civil court, the limitation.
That order one order we have passed in Mr. A. Biswas's case.
Lordship, in fact, one order has been passed by Mr. Justice Lordship Borua also. Lordship. Similar circumstances.
Because I had also passed under where Mr. Arnab Biswas was a lawyer. This relates to this board decree.
Sir, let that be, I will paste that, my lord, order business I collected.
Similar issue, lordship, here, lordship.
You file an affidavit.
No.
Because he will have a claim. Claim may be barred by limitation and all. File an affidavit. Otherwise, we'll say that you consider his case and otherwise.
No, sorry.
So you file an
Lord,
affidavit.
I'll file.
Yes. Mr. Upadhyay is granted a last chance to file affidavit inasmuch as this court has earlier granted time to file affidavit on many occasions. Full stop. List this matter.
2 weeks, Lord.
Give a date.
After 2 weeks, Lord, we need it.
You need to file an one-page affidavit. Simply that we do not admit this is the case. He is not entitled.
Lord.
And we'll send him to.
Lord.
When? 19th.
Problem.
19.
Have a good luck.
Yes.
Matter may be possible for the day, Lordship,
Why?
because her senior is out of station.
My lord, I'm for the private respondents, 3 and 4.
Who is representing Bongaigaon municipality? Name shown. Who is the respondent number? What is the number of Bongaigaon municipality? Though notice has stated to be served upon the respondent number 2, Bongaigaon Municipal Authority, none appears for such respondent. Full stop. In the aforesaid backdrop, the Learned Standing Counsel for respondent number 3, Learned Counsel appearing for respondent number 3, that is Deputy Commissioner, shall obtain instruction from the said Bongaigaon Municipal Authority obtain the record is it an elected or some deputy commissioner is executive, chief executive, or who is executive? Huh?
Executive officer, we are appearing for.
But who are you? You are for the
private respondent, my lord.
But what is your stand?
My lord, our stand is there is no difficulty posed to the petitioner.
No, forget about it. Have you constructed the shop in the public property?
My lord, yes, my lord, it is constructed there. However, there is no, my lord, we are in tune with the landlord. There is no objection from the landlord.
No, forget about who is landlord. If it is a property of municipality,
yes, ma'am.
Landlord is municipality.
Executive officer, Bongaigaon Municipal Board is not made a party in this petition.
Why necessary? Municipal board is made a party, represented by executive officer. The petitioner is permitted to take. Come on. In terms of the law, in terms of Lawajima Court's order dated 5/9/2022, notice is deemed to be served upon respondent number 2. However, none appears for the aforesaid respondent number 2. The response of the respondent number 2 shall be necessary for determination of the writ petition. Accordingly, the petitioner is permitted to take fresh steps upon respondent number 2 through Dusty to be routed through the registry of this office. Such steps be taken within a period of 10 days from today. An affidavit be filed in proof of effecting such service. Full stop. The respondent number, you are respondent number?
4, my lord.
Respondent number 4 has entered appearance, and he has been given chance to file an affidavit as regards the status of land/building wherein purportedly from where the respondent number is running the shop, isn't it? Running the shop, which according to the petitioner is an illegal construction obstructing the frontage of the house of the petitioner. Full stop. List this matter after 4 weeks.
21.
Yes.
There is
Yes, Deputy Commissioner, Circle Officer. Who are representing private respondent?
Service is completed by otherwise.
Yes, Circle Officer. Suit is pending. Declaration of right title, interest, this is partition, etc.
Yes.
No business of Deputy Commissioner. If
Yes,
the respondent number 4 wants to have some commission, he can have it in the civil suit. Heard. What is the steps or office note? Office note. In terms of heard Mr. Chakraborty, learned counsel for the petitioner, also heard MS.S. Borua for
Respondent number 2.
respondent number 2 and MS Bora Bordole, M Bordole for respondent number 1. None appears. Who is for respondent number 3? 3. You are 1 and 2. Borua is for 2.
And for
Who is for 3?
Private respondent.
private
3 to 7. There's the office note, Manoj. It says service is complete.
The come on. Office of Lawajima
order
was ordered at the 3/1/2023.
Yes, ma'am.
As per Lawajima court's order. The notice upon respondent number 4, 5, and 6 were duly served and the AD cards were signed. But this was not signed by them. Okay. Signed by some persons other than the addressee. And accordingly, notice was presumed to be served on the respondent number 4, 5, 6. And notice was deemed to be served under respondent number 3 and 7. Taking note of the provision of section 27 of the General Clauses Act 1897, read with order 5, rule 9, sub rule 5, proviso to sub rule 5 of CPC. First of this code is of the opinion that any order passed in this proceeding may adversely affect the respondents, and therefore the petitioner is permitted to take steps upon the aforesaid respondent through the stick and to file an affidavit effecting such service. First of the interim order is there?
Yes, interim.
Interim order passed earlier shall continue until further orders.
All right.
List this matter after 6 weeks. Please this matter before any other bench without me.
May please, your lordship. Lordship, we had filed an affidavit of opposition to the main case. However, Lordship, there is another repetition filed by one of the director, where interim order was granted because of the interim order granted in this.
Okay.
So I think those two has to be tied and can be disposed of. From Mr. Guru. Same FIR.
I was not aware of this. Okay. Learned counsel for the respondent number? 4. Submits that another repetition touching the same subject matter is pending before this court, pending adjudication, which is registered as WPC criminal /35/2023. The learned counsel for both the parties submits that both the matter be taken up together. Taken up, but this is a WPC criminal, whether this less bench 4 or criminal bench 5.
But this was registered by the same FIR on basis of the interim order granted in this petition.
Okay, accordingly, list both this matter. Once list this matter along with WPC criminal 35 of 2023 on.
Not inconvenient. Can it be after 18th of September?
Give a date, both of you.
18th.
Can be on 19th.
19th of September. Now, two issues here. According to you, all cause of action is in jurisdiction of this High Court. Okay. FIR was lodged in Gujarat. Now, it is the duty of the officer where FIR is lodged to see if he has jurisdiction to investigate. And if not, in terms of the CRPC, he will have to send back it to Assam. This is one way. So, this is fundamentally revolves around the jurisdiction. Now, second question of jurisdiction will come whether the action of the police officer, whether right or wrong, can be determined by the jurisdictional High Court or by this High Court. That is there. Yes. Because so, two cause of actions. One is for the purpose of registering the FIR. Yes. One is the purpose of taking cognizance of such inaction of the police officer. Yes. Which High Court will take up this? That Bandopadhyay, what is that case? That Chief Secretary West Bengal?
There is another strong matter also.
No, we are going to Supreme Court judgment. Alpon or Alpon Bandopadhyay.
Yes, sir.
Alpon Bandopadhyay or Aplon. I forgot this.
Okay. I'll take that.
That Alpon Bandopadhyay, who was a Chief Secretary of the West Bengal. That a famous case. Now, there the Honorable Apex Court has made this distinction. Jurisdiction of High Court as well as jurisdiction of the jurisdictional High Court and inaction in dissimilar matter. That relates to OA, Principal Step and Kolkata High Court or Delhi High Court. So this will be another issue. Of course, that has been referred to a larger bench by a subsequent bench opining that this may not be the correct proposition of law. But third question will be whether that will still be binding upon, because subsequent is an opinion only, not a ratio. Till that ratio is reversed. So this will be an important issue in this case. 19th, come prepared.
Yes.
Yes.
24.
Yes, what is this?
What my lord was referring, I think that was Alapan Baddabad.
Alapon or Alapon. Alapon.
My lord, in this case, we have filed the affidavit in the year 2022.
Yes, what you say?
My lord,
24.
my lord, we want to withdraw, my lord. Petitioner have got relief, my lord.
Okay. The learned counsel for the petitioner, your name please? Your name is there in the in the petition, in the writ petition. Is he here? Mazhar Bhai is here.
Yes.
In Guwahati, he is available in the court available.
Yes, sir.
Is he available today?
Yes, sir.
Okay. NS Mazhar Bhai, learned counsel for the petitioner, submits that the grievance raised in this petition by the petitioner has already been redressed. Therefore, nothing survives to be adjudicated in this petition. Accordingly, the writ petition stands closed, being infructuous. Interim order, if any, stands vacated. I'll tell you, Mr. J. Abedin,
R4
for respondent number 4, is also present before you. That's all.
Deeply obliged.
Hey, please, your lordships. I have entered appearance in this matter, lordships. I have filed my wakalatnama today, lordships, after the elevation of the previous counsel.
Okay.
And lordships,
Yes. Very serious allegation.
yes, lordship.
What is the stand of the revenue?
Nobody, except
Yes,
the
yes.
deputy commissioner, no one else has filed any.
What is the stand of the
appearance.
deputy commissioner?
Lordships, there are just two annexures which do not clench the issue, lordships. It is just a certificate and the committee, a report of the committee, the construction committee, lordships.
No, no.
Nothing is made out from there.
Yes, revenue. You are for Mr.
I'm for the deputy commissioner. We have already filed an affidavit. So here, the petitioner's allegation is that the government scheme has been made applicable in
Implemented
their
in a private land.
So accordingly, we have there was a total of 19 bighas of land, out of which we have categorized it. 8 bighas have been sold out at different dates. And that apart, the petitioner is claiming also that they are in possession of 15 bighas of land, whereas it is only 11 bighas.
Forget about that. Just given an instruction whether this land is a government land or a patta land. That's all.
Because from our instruction, it
No,
appears
because government, if you say that government has gone to that extent, then if somebody is not in possession, it's a patta land, government can take over the land and give it to a club. Then you are a land grabber, as simple as that. I will make responsible the officer.
It is said that the land where the construction has happened, it is in the name of Pope Namgarbar Sabha Mahotsav Committee. So this is a committee who is in possession of.
That's why we want a specific affidavit with the supporting
Jamabandi.
Supporting not only Jamabandi, supporting Jamabandi Sita, whether this land falls is a patta land or is a government land. And if it is registered in the name of Sabha Samiti, on which date and on what basis?
At least that specific instruction would suffice in this case.
Yes, that is.
I think he is representing the circle officer as well.
Yes.
Who is you are for respondent number 5 and 6? Who is respondent number 5 and 6? None appears. Hard. Okay. The present the petitioner has raises an serious issue
5 and 6 enter
as regards government taking over the land, patta land of the petitioner and constructing over the aforesaid land, some making construction over the aforesaid land for implementation of project under Parliament Local Area Development Scheme. Good stop. Though the Deputy Commissioner has filed an affidavit in the considered opinion of this court, such affidavit do not answer the questions raised in this present petition. Full stop. In view of the aforesaid, the circle officer, which revenue circle, is a party respondent?
Yes, Lordship. 4.
Circle officer, that is respondent number 4.
Respondent number 4, Lordship.
Respondent number 4 shall file an affidavit and which file an affidavit and shall incorporate the following facts. A. The DUG numbers and patta numbers of the land upon which the MPLAD scheme for construction of Pub Nam Borgap Sabhu Mahotsav compound is being proposed. Full stop. 2. The who are the recorded pattadars of the land?
Yes.
Give us the details.
Dag number ours is 240, dag number 240, patta number 19.
That's Dag number 240 and patta number
19.
90.
Yes, sir.
Can I interrupt? So if I go to paragraph 11, so we have made the difference of those pattas of the petitioner and also the land of this state. They are two different dags and different pattas numbers. So petitioner is having his possession over 240, whereas this construction has happened in dag number 223 of patta 25. This is a difference.
Listen to us. Listen.
We are in possession also.
Please listen to this. Full stop. What I've said? Huh? Who are the recorded pattadars of land under dag number
240?
And patta number 19.
Patta number 19 of village.
That is Tihu.
The land you claim.
Village Akhara.
Akhara Chowk.
Village Akhara Chowk. Under revenue circle, Tihu.
Tihu.
After Tihu revenue circle. Full stop. Third, if which is the land 230?
223.
What is the status of land under dag number 223 of patta number 25 of the said village, and whether such land is a government land or a patta land?
It's in the, or it is in the, because
patta land. Full stop. If the same land is registered, if Pub Nambor Bhag Sabha Mahotsav is a recorded pattadar of the said land, the circle officer shall clarify by what mode such land has been allotted or patta has been issued in the name of Pub Nambor Bhag Sabha Mahotsav
committee.
Please this matter.
2 weeks.
After 3 weeks. List this matter on 27. No, 27. 27th is a difficult day. 24th. Or you may give in the first week of October, no problem. 1st of October. 1st of October 2024.
Meanwhile, I may file a reply to the
In the meantime, the
affidavit filed by
petitioner
parties.
may file reply to the affidavit in opposition filed by the deputy commissioner.
Deeply obliged.
You want to say?
And I'm sorry, my lord, I missed the item number 47, my lord. I'm sorry.
What order is it?
My lord, actually, that is a contempt matter. My lord, notice was issued to the respondent also.
Service is not complete.
Service is not complete.
So we have asked to give you taking fresh steps.
I'll take steps.
Fresh steps. 2 weeks. Okay, we'll say that write it down. Item number
47.
In view of the office note dated so and so, the petitioner is permitted to take fresh steps upon the respondents. Decision to confiscate. That is the ratio.
Judgment is there, my lord. Hurriedly, I did not break up, my lord.
So we are adjourning it.
And it is next week, my lord.
On the prayer of Mr. Learned Counsel for the petitioner, matter stands adjourned. It is submitted by Mr. S.C. Kyal that during pendency of the present writ petition, the vehicle in concern has been confiscated under the provision of
Custom 115.
Section 115 of the Customs Act, and such order of confiscation is an applicable order under Section 128 of the Customs Act. Therefore, according to Mr. Kyal, this petition has become infructuous. However, Mr. J.I. Forward submits that he may be granted some time to satisfy this court that even after passing of the order during pendency of in spite of the order of confiscation, this court can determine the issues in the present writ petition, and in support of such decision, he want to rely on some judgments. In support of such contention, he want to rely on some judgments. Accordingly, matters stands adjourned and be listed. Give it to him. Listed when?
The lordship can fix my lord any day of 20th September, any day after.
After 20th, give it. 23rd of September. If possible, Mr. Kyle, keep a copy. Huh?
28 and 29.
Everyone. This case is for restoration of application, which was dismissed.
Have you filed the affidavit in terms of this court's order dated 14/8/2024?
Yes. Can we see the?
Where is the order? Order of dismissal?
26 month.
Where do you get it? Miss case?
Miss case 25 2023.
What is IA 4442?
IA for my lord, during pendency of the miscase, my lord, respondent number 5 expired, my lord. And I filed this IA for substituting his legal heirs.
So first, you'll have to make an implement in the IA miscase, is not it?
Already.
What is the issue here?
In miscase, my lord, already notice was issued and service is also completed, my lord.
When this respondent number 5 died? Prior to dismissal
During pendency of the
or after dismissal?
during pendency of the miscase, my lord.
During pendency of the miscase
yes.
expired.
Yes,
Before that, not. After disposal.
Yes, ma'am.
After dismissal, before, during pendency of the miscase. So miscase 25 is for restoration. And IAC 1442 for implement of legalism of respondent number 5 in miscase or in writ petition?
In miscase, my lord.
In miscase. So we'll have to issue a fresh notice if to the newly implemented respondent.
Already deemed to be completed, my lord.
Deemed to be completed upon whom? Upon the respondent number 5 or legal heirs of respondent number 5?
Legal heirs, my lord.
How can that be? Because
Lordship notice was issued in IA also, my lord.
no, that is notice is complete in respect of IA. Kindly understand. You say that so and so died, these are the legal heirs. Please issue a notice. Issue a notice, they have not appeared, we'll allow this petition.
No.
Now they become a party in the MC. Now,
Yes,
in the MC, they will be again required to issue the notice. Isn't that it?
Yes, sir.
Hard. You are Mr.
HL Oscar.
H.L. Oscar, learned counsel for the petition. The present application is filed for implement of respondent number. Where is your prayer?
Here is in IA, my lord. Page 7.
Implement of the legal heirs of deceased respondent number 5 and 6 in connected miscase number 25 of 2023. Isn't it? Arising out of WPC 1452 of 2012. This court, by its order dated 29/5/2024, issued notice to the legal heirs of the aforesaid respondent number 4 and 5. Office note dated 8/8. Lawajima Court's order dated 8/8/24 reflects that service has been completed. Full stop. However, none appears for the said none appears for the legal heirs of the implemented legal heirs of the deceased respondent number 5 and 6. Consider the pleadings as well as submissions made. Full stop. Considering the nature of allegation, nature of controversy, as well as considering the fact that respondent on the date of respondent number 5 and respondent number 6, cause of action survives, and accordingly, the present petition is allowed. Who are the legal heirs? Where do you get?
Page 7.
Yes.
Page 7.
Allowed. Allowed by substituting.
Legal years, my lord, legal years of respondent number 5, my lord.
What is your respondent number 5, huh? Not 6.
Yes, sir. Not 4, my lord.
No, but you have written it direct the substitution of respondent number 5 and 6.
No,
You have written.
No, lordship, respondent number 5 expired, my lord. I want to implement in place of respondent number 5, my lord, respondent number 5 and 6, newly.
Okay, respondent number 6, 5A and 5B. How can 5 and 6?
5 and
Come on, come on. Which are detailed, which are given in paragraph 5 of the present IA as 5A and 5B. Correct it, sign it and correct it. 5A and 5B. Huh? Correct the page out and give the initial 5 and 5B. Accordingly, present application allowed full stop registry to do the needful for correction. Full stop petitioner to submit furnish of amended cost title before the registry as well as to the learned counsel for the respondents for incorporating same in the record of this in the file of this case as well as in the record of the respondent's brief. What's the I dispose of you write it down in view of the implement of respondent number 5A and 5B in terms of this court's order passed in IAC 1442 in 2020/2024. Let a notice be issued to the newly implemented respondents returnable after 6 weeks. Full stop. Petitioner to take steps for issuance of such notice within 5 days from the correction of the cost title. Kuntu. A2 to hold bottom to article ISC, second to hold miscation. Make this dismiss for it now it will be now this is disposed of, this will survive. No. If it is allowed, then it will be restored. Yes, next case.
May I please? In this case, I am appealing for respondent number 2. Lordship may allow some other time to file our affidavit.
Who is respondent number 2?
Who is he is a principal secretary of the Thengal Kose Autonomous Council.
Lordship, various occasions, a respondent have taken.
Where is the tender notice?
Tender notice, Lordship, 5/11/2022, Lord.
Where is that?
Is on the
Lordship annexer 1, Lordship, page 13. Lord.
What is the condition?
Condition, it is as per the.
As is where basis.
Yes.
So if as is where basis, you are not aware that 15 years old vehicle cannot be registered. It's your fault. Why should they refund your money?
Lordship.
Isn't it?
Yes.
They have not said that this is valid, this can be registered. If these vehicles are, their life is gone, you can sell it in the scrap. Why should they return? You as a prudent businessman, you thought that I am getting a safari vehicle. At what price you have purchased it?
2,40,000, Lord.
To a vehicle which cost you around 20 lakhs, you are getting in 2 lakhs, and you say that they should register it.
Lordship.
No case. Why? What affidavit we can dismiss right now?
Lordship, it is a hard-earned money, Lordship. They have no knowledge about that, Lordship. That is why, Lordship, he asked the
DTO lordship and DTO informed me that
Your lack of knowledge will not give you any right, or that will not result in violation of what is wrong they have committed. They said as in where basis these vehicles are for sale. You purchased it and you
they
went
have
for
not
it.
mentioned the 15 years lordship. That is why lordship.
So as is where basis. This is a scrap. If you want say that I wanted it to be, no case for you on the prayer of Setri for whom? Respondent.
For respondent number 2.
Mr. Setri, respondent number 2.
Main 3.
On the prayer of Mr. Setri, Legislative Council for the respondent number 2, matter stands adjourned to enable him to file affidavit in opposition.
Highly appropriate.
May I please?
Yes.
In this case, your worship, on 30/01/22, the husband of the petitioner number 1 had expired due to hit by the unknown vehicle.
Item number
32, your worship. And thereafter, petitioner submitted an application before the district commissioner of Dhubri for consideration of her prayer.
Yes, you say that liquidation funds have been placed before the competent authority and steps have been taken for disbursement of the petitioner, which will take further 2 weeks time. It was on in the month on April. In the month of April, forget about 2 months. We are more than 4 months.
Lordship, we can also take instruction. I can also take because bank account number is also.
What is your instruction?
As per my instruction, they have not
Yet
Yes,
received.
I have to.
Because account number is
You ask
mentioned.
learned counsel for the petitioner seeks for a last opportunity to obtain instruction in terms of this court's order dated 3/4/2024, whether the payment has been transferred to the account of the petitioner, and if not, the reason thereof. Please this matter on
3 weeks, madam. 3 weeks.
not 3 weeks,
2 weeks, then. madam.
not 2 weeks. Already there is 2 weeks. You have taken months.
Take even to buy tomorrow after getting the order, madam. Definitely, I talk to them.
So we are fixing it after 10 days. You
Madam,
have the
madam,
instruction. No need to file affidavit. List this matter on after 10 days. 16th.
16th.
You just have the instruction. I have paid.
but-
This is the proof.
Okay,
Matter is there.
that much.
That much. Or if not paid, we are paying and this is the order.
My lord, this is a simple case, my lord.
Not simple. Very complex. Father, son.
Page 67, Lord.
After another day, my lord, filing
Page 67, may I please in nutshell, my lord. What happened, my lord? We as per.
See what division bench says. You have invited comment from the division bench.
Earlier, my lord, see, when this case.
Correct me if I am wrong. Let us not waste time. Your father or predecessor interest files an application that see I am so and so, I am possessing a land. Please give me settlement. That was disposed of. Huh?
Under T cultivation.
Under T cultivation. That was disposed of settlement to allow you to your father to file application.
That was, mandamus was issued, my life, annexed the in 1999, directly asking them to settle the land. That is the case. Mandamus was issued.
But settle the land, you will have to file an application.
We have
How will
already
they-
filed, my lord. That is the thing.
Hmm?
And further, page 67. if your
Because
lordship-
settlement of mandamus will not mean that flouting, mandamus cannot be read into a situation that flouting everything you are directed to give a settlement.
Our case is, my lord, here that we have filed our application, we have annexed the document and the application.
But you went to the division bench and said that and division bench observed that you never filed such application after 22 years you have come.
Is what, my lord, we have filed, my lord, on apprehension that they will evict. Subsequently,
Understand that apprehension has resulted in observation by the division bench.
not decided on merit.
Not decided, but it says the effect, the division bench says that we are not interfering, we are not passing any order because this is the fact.
Division bench, my lord.
Let us not go further today. You are in possession,
Yes, sir.
you enjoy for some more days. What is the requirement of this? You want this land?
Yes, my lord. Lordship may kindly see, my lord, the earlier round of litigation. That order, my lord, lot many petitioners, my lord, came before this honorable court, including this petitioner, my lord. The order starts from, my lord, page 59.
58, my lord, annexure J to the writ petition, my lord. I'm troubling my lord with all these papers, my lord.
No, that's why he said simple, according to which not a simple.
No, paragraph 67 page, lordship will see.
My lord, it is my turn, my lord.
From then judgment.
আপোনাৰ কিবা আছে যদি কৈ লওক এবাৰতে ক'ব
May I point out, my lord?
Yes.
The said judgment, my lord, paragraph page 67, paragraph 20, my lord, and paragraph 21, we are directed to submit representation before the deputy commissioner, and deputy commissioner asked to submit a report. And why we have came now, my lord? Before the report has been submitted, nothing was done, my lord, but all of a sudden they issued a notice to us, my lord. That is the thing, my lord. Therefore, this honorable court
Lord,
state the
please
notice.
in
my
this, my lord, common order starting from page 58. There, lordship may kindly come to page 60. 60 is, my lord, the link case. That is Konpona Hazarika. Konpona Hazarika is the present petitioner. Then, my lord, the operative portion of that order, my lord, at page 67, paragraph 20-21. Admittedly, my lord, this land is a VGR land. This land is a VGR
Where
land.
is the earlier judgment whereby revenue boards or this decision was challenged?
Yes,
my lord.
that is, my lord, annexure A.
Page?
Page, your lordship will find at
Start,
page
my lord, from
31.
Page 31, yeah. The operative portion, lordship will find at page 34. Page 34, my lord, the third paragraph. May I read it, my lord?
This mercy orders creates all the problem.
Yes.
It ought to have been decided whether Board of Revenue's decision is correct or not.
Yes.
That's all.
Now, my lord, by this order of 1999, this honorable court, my lord, permitted the petitioner to make a representation within 2 months, which he has duly defaulted, my lord. He has defaulted. And he never filed any representation within 2 months, my lord. So therefore, my lord, he himself has not, my lord, complied with the direction issued by this honorable court. This is one aspect of the matter. Later on, my lord, way back in the year 2021, my lord, when, my lord, eviction notices were issued, my lord.
What
then
happened to the others?
Others are still enjoying, my lord, here.
Huh?
No notice was issued to them, only to me.
Petitions, my lord, are all disposed of, my lord. Nobody, my lord, except the petitioner is now, my lord, in occupation, my lord. That is spelled out, my lord, in the order. Therefore, I have drawn lordship's fine
Others are
attention.
in occupation, my lord.
Lordship may kindly see, my lord, page 67. This will clinch the issue, my lord, page 67. This is the order, my lord, the detailed order, my lord, where affidavit had been.
How much land in possession according to you?
More than 8 bigha, my lord.
More than 8
And
bigas.
I have.
Now, my lord, the total quantum of land is, my lord, 25 bigas. Admittedly, 25 bigas of land, my lord, are VGR land. Now, way back in the year 1998, my lord, for the purpose of constructing a mini stadium in Tiok, the Upper Assam town, for greater public interest, in order to cater to the needs of the larger interests of the society, government allotted, my lord, the entire 25 bigas of land to the Sports and Youth Welfare Department.
And what is the alternative rent for VGR?
Alternative land, my lord?
Or for VGR?
That is-
VGR land you cannot.
They have utilized, my lord, that is the thing.
No, if it is, my lord, for public interest, my lord, if it is for public good, my lord, therefore, my lord, the.
No,
Yes.
that is not, may not be subject matter of this.
Yes,
But one question will still remain.
my lord.
When you, maybe for public interest, VGR itself is a public interest.
Yes, yes.
Your settlement rules, your land and revenue regulation, everything prescribes that it will not debar you from allotment of VGR land in favor of anybody.
Absolutely.
But the only condition is that you will have to identify and equally give VGR land and create a VGR.
Absolutely. Now there, my lord, way back in the year 1998, this happened. Nobody questioned, including the petitioner, because the petitioners are in wrongful occupation. They are not in, they are in wrongful occupation, my lord. Nobody
Now the
questioned.
stadium, because of this
Because
stadium.
of this, my lord, the
No, no.
stadium cannot, my lord, be constructed.
My lord, there is a map, page 48. We are outside the boundary. We are outside.
We'll
the
have to hear this matter
Yes,
next week.
that is why.
Next week. Next week.
No, no, my lord, we are in an urgency, my lord. Because of that, my lord, one after another repetitions are coming, my lord.
Matter comes all of a sudden. Everything is sudden in this life.
Next.
Isn't it, Mr. Borpuzari? For them to everything is surprise, isn't it?
Lordship has authored Salahuddin, my lord. Post Salahuddin, what remains in this repetition, my lord? I am putting a question to myself.
Yes. That's why I'm saying that.
Post Salahuddin, my lord, Lordship has authored Salahuddin, my lord. What remains, my lord?
Our contention
We have
is, my
covered
lord,
all the requirements in Salahuddin,
As
my lord.
per the-
Notices have been issued. They were given all opportunities to explain, my lord.
that is not our contention. Our contention, as per the earlier judgment of this court, they were specifically directed Deputy Commissioner to submit a report.
But they will have to file representation. They did not. They did not.
Where is your application? Because division bench says you slept over.
Yes.
That's why I have
That is
put the first
fact.
question of division bench. List this matter for,
Lordship, kindly-
list this matter on when?
Lordship may kindly keep it part heard, my lord, and Lordship will kindly observe, my lord, that endeavor will be made for disposal with all respect.
No, we'll dispose it of. No
Yes.
part heard is required, no
Yes.
endeavor is to be recorded.
Yes,
We'll because today we are in the midst of two hearings.
absolutely. my
That's
lord.
why we are one criminal appeal if time permits and one part heard hearing matter, old matter. And I think one criminal hearing PP is waiting.
My lord. My lord, then can it be, my lord, on,
Give it.
my lord, 10th of September, my lord? 10th will be Tuesday.
I have some difficulty, that's sure.
10th of September.
10th of September will be Tuesday, my lord.
And what is your date? 18th. 18th of
September
September.
will be again Wednesday, my lord. It will be a, my lord, non-hearing.
19th,
19, my lord, some hearing matter is fixed.
17th.
17, it can be.
Then 12, my lord, 12th of September. 12th of September is a Thursday, my lord.
That's you'll have to say. 17 because we have fixed the 17 maybe free.
17 is Tuesday.
Tuesday.
My lord.
17 is
I'm so obliged, my lord.
Earlier interim.
interim order parcel shall continue till the next date of this thing.
My lord, so far the writ appeal and judgment, my lord, there they have, court has said the single judge order, honorable single judge, saying that.
That we understand.
Yes.
The court has said your prayer was something different. You are not happy with the single judge's order. But in the process, certain factual determination is made.
Yes.
Then how will you'll have to answer it? We are not saying anything. But you have invited those comments. Can we say no, division bench in observation is wrong?
The order was pointed out, my lord, before when the interim order was passed, my lord.
No, that interim is something different.
Yes.
Interim and final determination are two things. Interim that we need examination, so therefore we are protecting you. Now we'll determine the
This
examination.
case is basically against the notice they have issued, not for eviction. They told us to submit the documents for settlement.
Okay, then
We are only late by some days. That's why court protected us, saying that you file your document. We have filed, my lord. Recently, last year.
Okay,
we have filed.
we'll take call on that. What is your prayer? What is not? What can we
Only-
pass?
only
We
that-
are not, if they are not seeking eviction, we will not say evict
They are
them.
not seeking eviction.
What will say that this, if at all you have a right to reply at this stage, and okay, it says you reply it, and within this period, you determine in terms of the law laid down in Salahuddin, that's all. Yes.
Obliged, obliged.
I'm so obliged.
Yeah, discuss it.
Item number?
34. Matter is waiting for instruction, lordship.
Huh?
Matter is waiting for instruction, lordship.
What is the case?
So my ex gratia grant, my lord. We have filed our affidavit in annexure, page 44, annexure 1 of our affidavit. We have actually, my lord, this incident happened, my lord, in Sunitpur. So, my lord, it's a Dorong, so we have written to Sunitpur, my lord. Lordship will find page 40. Probably, my lord, I'll have to take instruction, my lord, about this because we have.
Okay.
MO case also there.
You thus
One, I know.
learned counsel
Paisa po na.
press for an adjournment to complete her instruction as regards present status of the payment.
Payment
Full
status
stop.
of the payment.
Prayer stands allowed. List this matter after 3 weeks.
Lordship.
If I lordship, probably his grievance has been mitigated, lordship, in fact. His grievance is that the lordship, the AC is blocking his payment, lordship. Now already.
Mostly. The petitioner person is not present. The petitioner person is not present on call. He was also not present on 14/6/2024 and 27/5 2024. Full stop. Mr. N. Upadhyay, Learned Counsel for the Education, submits that he has received instruction that demand proposal for fund for the works in question, that is constructor of solar powered capital MDTW scheme in Poop Sorupathar area under RIDF XXB within bracket Nabar has already been placed. And according to Mr. Upadhyay, the petitioner payment has already been made to the
Not
petitioner.
made, Lordship, process is on.
Process for payment is on an advanced stage. Full stop. Be that as it may, as the petitioner has not petitioner in person has not appeared on call, this writ petition stands dismissed for non-prosecution. Let him see if he comes for restoration.
Lord, no. Okay.
That gentleman.
Yeah, Lord, that particular gentleman.
Kuntu?
Lordship matter maybe take over. Thank you.
Have you got it?
Yes.
You are supposed to reply. Everything has been done.
My
Isn't it?
senior will come after 10 to 20 minutes.
Well, they have also replied and the notification is the next.
Okay, very good. That is what I wanted. See, we are not questioning the authority of license and in what manner you are giving it. This is not a subject matter of this. But subject to what you say, if we go to certain provisions, that how you reconcile the entire scheme of that for our knowledge, that may not be. Second part is Mr. Das may be right in saying that the way a document is interpreted and what the employer requires within their domain. Fine. According to them, Mr. Das, you also just take note of. According to them, in the affidavit, what they say is that we need, according to us, for the purpose of this contract, a valid certificate is a certificate which is either issued and applicable for state of Assam or for the district of Sibsagar. They are within their domain. That is fine. But next question then will come. Okay, fine. It is their domain. Why should we interpret? According to them, they require it. They require it. No quarrel on that. We have accepted his argument. Now, next question will come. It is not a document or any other document. It's a license whose validity is to be examined when it's a question of validity in the touchstone of the act and rule. Isn't it? Admittedly, under the rule, act and the rule, the certificate of the petitioner is not an invalid certificate. This is a valid certificate. No doubt about that. But the employer says that according to us, this is not a valid for purpose of our thing, our work.
In the
context of the contract, we do not want this kind of certificate. That may be valid in terms of the act, but according to us, this is the validity.
As regards the jurisdiction.
As regards the jurisdiction, that this is the, according to us, for this contract, these two certificates will all be valid. Very well. But otherwise, that certificate is admittedly valid.
It's a valid.
It's a valid certificate.
In Kamrup.
So therefore, in that context, can it be termed as a hidden criteria? Because is it not? It is not a normal document. It's a validity of a certificate issued by a competent authority, which is otherwise valid. But they do not want to, they want to give a different meaning to a validity. isn't it? Is it not required that us we want a certificate either issued by this or either issued by those? Will it not mean an hidden criteria? Number one, just listen to it. Just answer it. Otherwise, you are satisfied with that argument. See, whether I am being able to express or not, I do not know. Certificate is here a certificate, labor certificate. Labor certificate is issued by a competent authority under the jurisdiction of an act. Admittedly, the petitioner is having a valid certificate. Under the definition of the certificate, under the act and rules. The employer says, according to us, this is not a valid certificate because we are interpreting a valid certificate to be issued by X or issued by Y. Fine. In terms of contract law, they may have that satisfaction. But is it not necessary to say that a certificate of labor contract should be either this or that? Because here is a question of validity relatable to a statutory provision, not their independent thing. Otherwise, this is a valid under a statute. But they want to say our meaning of validity is different, we will interpret differently. Is it not necessary in that context to disclose that this will be a valid certificate? This is one aspect. Other aspect is, what is the object of insisting on a certificate? That they have not disclosed. In the affidavit, they have not said why they need a certificate. Now we'll ask them certain clarifications.
May I?
No, yes, we'll hear you later on. Let us ask her some questions. Now,
because, I have done some homework with regard to this establishment, which we were, interpreting on the last occasion, with regard to that place. I have just
no, that will come.
I'll try to bring
no, that everything will depend upon the first question.
hidden criteria.
See, you want to say a valid certificate to be invalid. You are treating a valid certificate under the statute to be an invalid for the purpose of the contract.
But
we are
but
accepting.
If I put it, whatever has been fallen from your lordship, if I put it in this manner, there is no iota of doubt with regard to the validity of the labor license granted to the petitioner.
Yes.
There is no iota of doubt. But if we consider the scheme of the act and the rules, then and the vis-a-vis the contracts, then the issue is with regard to Sibsagar.
No, you are going somewhere else.
No,
what I am asking is, what is the tender condition?
There,
the contractor must have a valid license. That's all. Valid contract labor license.
But that valid what I'm trying.
So valid labor license, if we general parlance will mean a valid labor license in terms of.
That valid labor license has to be understood in the terms of.
Therefore, we are even giving that liberty.
Yes.
That you are at a liberty to interpret a contract, a license, which is otherwise valid under the act to be invalid. We accept it.
The authority has examined the certificate as regard its applicability. Whether it is applicable to Sibsagar.
Oh no, what is the terms of the condition?
Terms is valid.
So therefore,
valid
they cannot do whatever they like and interpret. What is the term of the condition?
They have interpreted it that whether it is applicable to Sibsagar or not. So
Please,
that is why
Mr. Nath, what is the condition?
That is what they have done.
What is the condition of the tender which has been, for which he is not found responsive?
Should have a valid license.
Should have a valid license.
But here, these questions have rightly fallen from your lordship, Lord, but the projection made in the writ petition is on a different footing. That is why, my lord, possibly the reply has not come. Ultimately, the projection made in the writ petition is that the certificate will come after I get the contract. I have a.
We are coming to that. So this is what have come to our mind. We want your answer. We want your answer. That can be your answer. So let us frame the issues.
Yes,
this is one.
Logic.
So suppose you want to say a valid license to be an invalid license, you have a right to interpret as per your convenience, not for any other purpose, but for the purpose of this contract.
This contract.
According to you, we need a certificate which is issued either by the applicable to the jurisdiction of state of Assam
Applicability.
or by the Jora. So these two license will accept. Is it, will the Article 14 will not demand a clarity on this? Because you simply say, if he says no, then it's no. We want an answer to that. But because we are very conscious about Article 14,
Yes.
mind it.
Correct. Yes, true.
It is not a situation that because I am a contract, I will do whatever I like.
No.
No, that is not.
Better
So
authority-
therefore, you also deal with Jasper's Long and Datta Associates. Article 14 is very important. So these are the two issues. We
Wrong.
accept that you can say that we will accept this license only, not this license. Is it not necessary to say to the intending tenderer that we need a labor certificate only of having these two character? This is one.
Gotcha.
Now let us come to, I want clarification. You come to clause form 4. Form 4.
Yes.
Form 4, clause 4. Subclause B.
Duration of the proposed contract work, give particulars of proposed date of commencing and ending.
Just take note of it.
Lordship.
Why this is required. Then clause 7.
Whether the contractor has worked in any other establishment within past 5 years, if so, give details of the principal employer, establishment and nature of work.
Okay. Now come to form 6.
Form 6.
Come to clause 2. First, license is hereby granted to so and so, so and so.
Yeah.
Okay. Now come to clause 2.
The license is for doing the work of so and so.
Doing such, I will not complete this method today. I want to give this is a food for thought for you, Mr. Das. Not. The license is for the work of
nature of work
to be indicated
in
in the establishment of work, name of the principal, at
place of work.
Place of work to be indicated. Why these are necessary, statutorily required? If you say that there can be a
But,
you need not answer today. We are not closing this.
Logic.
Have appropriate things. We want to clarify whether whether he has made out a case or not. We may not go to all this, but we take it to be an academic thing.
At a larger thing. Because some gray area.
Because whatever we write, this will have a certification to a license.
True.
Kindly come to this doing the work of. Now go to that clause 4A and B of the application.
Application 4.
Particulars, the nature of the work which so and so, duration of the proposed contract work, give particulars of the proposed date of commencing and ending. Now come to clause 2, the license is for doing the work. So if that be so, suppose we are not concluding anything. If that be the so, will a license be not required for the specific work?
But this is corresponding to Rule 25.
We are coming to that. We will come to that. This is just an introduction.
Yes.
The license is for doing the work of so and so in the establishment of so and so, name of the principal at.
If we go by this, then only after allotment of work you can take it.
Now come to form 6. Form 5.
Okay.
certified that I have engaged
I have engaged.
or proposed to engage.
This proposed to engage, it has been inserted in 1991. There is an amendment.
Maybe 1991.
91.
This was applicable on that on the date of application also.
Yes.
So what do you mean by I have engaged? Certificate when you will declare, when you will certify to the licensing officer to give a license to a contractor in what conditions? Either I have engaged him
After award.
or after award or I propose to engage.
Propose to.
Propose to during bid. So how do we read all this with the interpretation of the employer? Now come to 25.
25. Rule 25 is forms and terms and conditions of license. Every license granted under subsection 1 of section 12 shall be in form 6.
No, these are not. Now I'll take 12. Now come to 32. There is a provision of temporary.
Grant
Now
of
we'll have to
temporary-
read the rule with this. Read it.
Grant of temporary certificate of registration and license.
When?
1, where conditions arises in an establishment requiring the employment of contract labor immediately, and such employment is estimated to last for not more than 15 days, the principal employer of the establishment or the contractor, as the case may be, may apply for a temporary certificate of registration or license to the registering officer.
So
or the
is it not
licensing
relatable to a work? Because it says that 15 days, if shorter period, 15 days you want to engage temporary license. Is it not relatable to a work? Or can it be a general?
No, this is for a work.
Is not it?
Yes. this is for a work.
So therefore, can you read 32? It says that temporary. So in case of temporary, we can give temporary is this period. Others also, ultimately, all licenses relates to a work and specific contract. So therefore, what will be the object? Then question will come of insisting a license. Then it may be subject to what you say. It may be to know that whether this person is having an experience of using contract labor in past.
Because the objective is to
So
protect
if
the interest of the contractor.
object is that, and if license is otherwise required to be given, then what will happen? We will have to answer on this. When? Just Mr. Not go through it. I have gone through it.
Got it.
He relies on his judgment, accepted. It is accepted. They are within their power to interpret how they like it. But all these issues we'll have to answer since debate has started.
True.
Get it?
I got it.
Day after tomorrow?
No.
Wednesday is a holiday.
Wednesday is a
I thought I will, and you have also answered many things because your whole case is in a different footing.
One statement I have categorically
So we'll
stated.
see that. We'll hear you. We have not heard you till now. Since we had some ideas, we get it clarified from the respondent. Some things are cleared from insist on a license as they want. There may be three kinds. They may say we want this license only, no problem on this. But whether that is not his case, he has not said that had it been there. But this is ultimately Article 14.
14. True.
Lordship, in the first question, Lordship, that the valid license. That question.
Thank you.
This is not the first case where first tender where this what is used. In the previous tenders, they in fact the Malan.
We are raising some question of law. Don't argue on facts. Was it what the question I have raised? Was it issue and decided? Yes, tell us. If no, then where are arguing on facts? We have raised some legal issues. You can, if you can answer, you can answer right now. If you cannot, don't argue. Just assist Mr. Nath. He is having an interest. Definitely will protect. We know our limitation in 226 jurisdiction.
Correct.
But here is a case, it's not an interpretation as a document or a term of contract. Here, a interpretation of a license which is otherwise valid, but we want to say it to be invalid. They are having that power, we presume that. But if they are having that power, is it not required to say that we want to declare a valid license to be, we want to treat a valid license to be invalid? And therefore, you will have to submit this kind of a license. Only valid will not do. Valid should be qualified.
Term is not specific.
Not specific. So we want a valid license. He has given a valid license. Can you reject it? Think over it.
They went on applicability of the license, whether it's applicable or
So
not.
if applicable,
as
so
per
therefore
rule.
they are within their right. They could have said that we want a license for all Assam only. Oh, no, we do not want any license. They are within, they can decide whether they want or not. But they will have to intimate the intending tenders that yes, I want this. Other issues, these issues will come. Whether license will be required once tender is given or at that time of bid that we are proposed to engage in, give the license.
But can we try it on Friday, Malad? Because in miscellaneous day, Malad, in the second half, Lordship can, Malad.
Yes, miscellaneous the second half is better rather. Friday.
Friday at 2.
Friday will finish it up, Monday will
Yes,
deliver the judgment.
Yes, Friday at 2. And
I'll also try to assist your lordships, not as a counsel for the respondent number
Yes,
5, since
see,
it's a law.
this is the problem of this court. These are coming into the mind.
Definitely. Lord, we are bound to answer the queries raised by your lordships, my lord. And
I do not think these are irrelevant questions.
No, absolutely correct. My lordship is absolutely correct. These questions are relevant. And I'll also try to assist your lordships, not as a counsel for
Yes,
respondent number 5, as an officer of the court, my lord.
He relies on a judgment that is in a different context. I do not think that is in a different
In
context.
fact, in that Puja Associate judgment also, and 12 and 13.
Here, their case was something different. Their case said that give him a permission to give a license. That has not entered into this area.
That is my instructions may be kept on record.
Okay.
That notification has come.
Okay. In terms of this court's earlier order, Mr. D. Nath, learned senior government advocate, has produced the notification issued by the state of Assam under in exercise of power under section 6 and 11 of the Act 1970. Full stop. Same is kept on record and marks at document X.
I'll have to take up on Friday, my lord.
Friday.
Fine.
Your lordship, the interim order passed.
Interim order passed. They will not do anything.
May I please, Lordship is burdened with so many cases. I will make short.
Yes.
Only the points I will.
Yes, points he has raised, and we will also deal with Mr.
Yes.
No, the doctor has specifically said he will rely on this. You are also there. So we'll deal with that only. Basically, violation of 52A.
Basically
violation of non-adherence of 52A.
52.
So we'll deal with how far 52A is important, to what extent it can be substantial compliance, non-compliance, what should be.
Yes. To the refresh, just I am going to the FIR, because 4-5 lines FIR, they call the text, I am taking the paper book.
Will you give some short note or I will write it?
I will, after that, I will submit a short note, I just cover the only points,
Okay.
because
FIR?
For brevity, yeah. FIR is at page 4, Lordship. Lordship, may kindly take up the paper book.
Paper book is here. Yes.
Page 4 is the FIR, Lordship.
Page 4. Yes, CBI. It's already 3. Mr. Pathak, he's having some difficulty today in com. So till 3 he was supposed to be here, but I do not think. So we'll take it up when tomorrow? Tomorrow by sleep. He has completed more or less his. After your argument, he will add, and if you want to add some 2-3 more points.
Let him complete, Lordship. Let him complete. Just after that.
Okay, tomorrow you complete your thing, and we'll then tomorrow, if possible, we'll do your part.
Yes.
Page
Page 4.
Page 4.
Hmm.
Which refers to the above GD number, I have the honor to report that today, edition such and such date at 12 noon, I was detailed with staff for bazaar duty at Gulabganj Bazaar area, and while I was conducting bazaar duty at about 1:20 p.m., one suspected motorcyclist has been detained on suspicion. I checked the motorcycle bearing such and such and recovered 6 fancy dial cup syrup 100 ml, and this is the my hall and such and such. Accordingly, I informed the matter to OC Gulabganj PS, CI Gulabganj, then SI Baikuntha Boisha has immediately arrived at the PO as deputed by OC Gulabganj PS and seized the recovered contraband items and other goods after obtaining authorization from CI Gulabganj. Later on, SI Baikuntha Boisha brought the seized contraband items along with a motorcyclist named Sasensa Mazam Ali and others. During my preliminary inquiry, it came to know that the apprehended person is habitual drug peddler and Sasensa. So here, your lordship will find, manner that the case has not started from a prior information.
No, not private principle.
So
It was spot.
It was spot.
Spot.
So 41 and 42 doesn't apply in this case. Man. That is one. In case of 43, man, on the spot recovery. Man. So after my lord, after seizure, my lord, whether it is written down, whether it is sent to superior officer, that part will not cover, not be required in this case, man, because section 43 is not
Applicable.
specific. So this is one part, my lord. Now, my lord, after the seizure, my lord, after the my lord, then he has informed the other OC, my lord, and OC has deputed SI Baikuntha Boisha for the seizure, my lord. He has made the seizure, my lord. And on his seizure, he has recovered 11 numbers of cough syrups, my lord, and that came into the commercial quantity, my lord. Other tablets were seized. I am not going to that part because they are not of commercial quantity. Only the cough syrups. 3 types of contraband were seized. Only the cough syrups were on being weighed. It has crossed the commercial level. Now, after that, the most importantly, after that, sampling part, the PW4.
Basically 51 sampling part.
Sampling part, that is what main question.
Main question.
Yes, and that is what my learned senior friends are good, and other 2-3 things I'll also deal with that, but mainly samples, after that, I will go to the
Sampling is those evidence which are this.
Yes, PW4, he is the person, who has drawn the samples before the magistrate, I'm making it short,
Where is PW4 page?
PW4, it is page 14.
Page 140?
14.
One.
This is the paper book.
Okay, 14.
FSLP is there. Submitted statement.
What is the certificate was exhibited as?
Yes, certificate was exhibited as, it is there, as page 83. Page 81, lordship, is 81. Lordship will find that it is the sampling procedure is as per. I'm not reading the whole evidence, Page 81, your lordship will find the inventory.
Just a minute. Kindly see the record.
Yes, record.
PW11, exhibit P11.
Yes, exhibit P11.
Is it exhibited?
Exhibited as, my lord, exhibit P11, PW4.
Seal and signatures of magistrates is there, judge is there. Because he has not any, during shift, there is no exhibiting. He has not exhibited. Who has exhibited this document?
Lord, who said that, my lord? Not
If you go to Pranab Kumar Deka, if PW4,
yes,
where is his statement that he has exhibited P11 and P12? Where is his statement? Marking of doc.
Page 16, my lord.
Yes.
Page 16 of the paper book, my lord.
Okay.
And first line, my lord.
Okay. Okay.
Exhibit P11, P4 is the inventory, P12 is the signature of asset. Along with the inventory, my lord, the certificate. P11, page
P12 is the?
Yes, ma'am. P12, P4 is just list of samples.
P11, P4 is the inventory.
Inventory.
Is P4.
Yes.
P12 is the list of samples.
List of samples.
P13 is the authorization
Authorization
letters.
letter, that is, madam, for seizure, madam.
P4 is forwarding
Report of the
PW15 is
sampling.
FSL report. Okay.
FSL is a
Where is
receipt.
the magistrate certificate? Is
Magistrate
exhibited.
certificate, that is what I am, madam, saying, page 81, Lordship, may kindly. This is the, my lord, annexure 1. Well, why I'm saying this annexure 1, my lord, it covers under the notification of 2015, my lord. In the division bench judgment also that relies on, my lord, that since the date of occurrence is
2015 applicable. No doubt about it.
and there, my lord, specifically, my lord, annexure 1 is the, my lord, this is my inventory along with the certificate, how it is to be there, my lord, format has been given, my lord.
Okay.
And it tells with exactly what is there in the case, my lord.
Okay.
Your lordship will find annexure 1.
P11.
P11, PW4.
PW4.
Yes.
As per
annexure 1.
Annexure 1.
Of the notification of 2015. Your lordship will see page 81, annexure 1.
That here, that Mr. Doctor has already
Yes.
given?
Yes, that has been given in the argument.
In the
also,
written
my lord.
argument. Okay.
Written argument also. In the written argument part also, my lord, I have seen, he has also mentioned the this 2015 notification, my lord. Yet your lordship will find on Mr. Doctor's, my lord, argument, my lord, your lordship will find at page 40.
Same.
Page 40, my lord, your lordship will see the format, my lord. And then last part, my lord, if your lordship tallies with it, my lord. Case
So
number
see that
is in-
according to you have recorded,
yes.
P11, P4 is as per annexure 1 of the
Yes.
notification.
And-
That you're going to have
Yes,
recorded.
and 41, my lord, page 41 is the certificate, my lord, along with the.
That we have
Then
seen.
there
Page
is-
not 41,
Yes.
page 81.
No, 41 is the, my lord, that argument
Okay.
submitted by.
That annexure.
Annexure.
Okay.
In annexure 1, my lord, it covers the inventory and also the certificate. So my lordship will find in page 82.
So this is annexure to NDPS Act.
Yes,
Okay.
next. Page 82.
That certificate is there, I have seen.
Certificate is there, madam. And certificate is also with language and everything, madam.
Same.
It tallies with the annexure 1 of the gazette notification, madam. And the division benches, as per the division bench, my lord, is specifically stated that in that case also there are some loopholes, madam. There is not, that is why that judgment has been passed, madam. And annexure 1 along with that has been relied on. And say the 2015 notification will apply, and that is why, madam, this inventory and.
Is there any ratio in the judgment that there should be 3 separate
No,
certificates?
nothing like that.
Nothing like that. I
Nothing
was
like
saying.
that. Nothing like that. There is very specific, my division benches.
I've seen that. There is no, I could not find out that
No,
it
ma'am,
should
there
be
is-
separate.
No, nothing, my lord. It is not the mandate of law, madam. The lordship will find what division bench, the points are, my lord, discussed, my lord. That, paragraph 23 of division bench judgment, lordship, we can take up the, argument that has been applied, my lord. It will be very clear, man. Paragraph 23.
Dictation. Just a minute. এইটো ফাইলত আছে অংশমান কৰা ফাইলটো তাতে টেবুল আছে
May I pass a copy, man? I have the document.
give us Since I was reading it, I think I have left in my table.
Copy it, yes.
Okay.
Your lordship will find, my lord, para 23, my lord.
Para 23.
Yes, in the judgment, my lord, it is page 17. What should be there as per that has been explained by.
No, that we have already recorded.
Yes, that is your lordship will find, my lord. Just time for the sake of repetition, where any contraband or conveyance has been seized and forwarded to the officer in charge of nearest police station or to an officer empowered under section 53. Here, forwarded to the officer in.
This is. You take this.
Fine, convenience of as per section subsection 2 of section 52A, where any contraband or convenience has been conveyance has been seized and forwarded to the officer in charge of nearest police station. That is, in this case also, my lord, after seizure, it was forwarded to the officer in charge of police station or to an officer empowered under section 53. Such officer is required to prepare an inventory. That is one inventory. Prepare an inventory of such contraband or convenience containing such details mentioned therein for such identification, particulars of contraband, what some details for identification that has been specified. As the officer in charge of the empowered officer, as the case may be, may consider relevant to the identity of the seized contraband. That is to for the identification, some thing has to be written there regarding. Yeah, that is there. And in proceeding, the officer has to make that officer, my lord, the officer has to make an application to a magistrate for the purpose of certifying the correctness of the inventory so prepared, my lord. So, my lord, that your lordship will find the officer in the. The officer has to make an application to a magistrate for the purpose of certifying the correctness of the inventory so prepared. That is already prepared inventory that was prepared by the my lord, in the first instance, my lord. So that inventory, along with then taking in the presence of such measures photographs of such seized contraband or conveyance and certifying such photographs as true, allowing to draw representative samples of seized samples in the presence of such magistrate and certifying the correctness of any list of samples. Here the list of samples are there, my lord, in this case.
Just a minute. Final application to magistrate for purpose of a certifying the correctness of so prepared.
Inventory so prepared.
For taking in present magistrate photographs of such contraband, conveyance, and certifying such photograph are true.
Yes.
Allowing draw representative samples of such samples in presence of magistrate and certifying the correctness of list of samples. Okay.
So in the division bench judgment, there is no list of samples and there is no certificate. That is why, my lord, that is on the backdrop of that circumstances.
Now, where are these here certification?
Here certification, I am relying on that page 82, my lord.
Now, first is page 81.
Yes, first is page 81.
Then page 82.
Page 82. Certification, your lordship can kindly read, my lord. Certification by the magistrate under section 52A3.
Page 82, na?
Page 82 of the paper book, my lord. Where is the? This is exactly what the magistrate has to satisfy as per annexure 1 of the notification. Whereas the above officer applied to me under subsection 2, section 52A of the Act to certify the above inventory, and subsection 3 of that section requires any magistrate to whom an application is made to allow the application as may be. I have been satisfied that the above inventory is as per the seizure documents and the consignment of seized goods related to the case prescribed before me certify the correctness of the above inventory.
Now list of samples.
Now again the next paragraph 83 is the list of samples, madam. Here also it is exhibited as exhibit P12.
P12, PW4,
PW4.
certified to be correct by the
Yes,
magistrate.
madam. Now your lordship will find exhibit P12-1 is the signature of special judge and the signature of the magistrate.
And what about where about the photographs?
Photographs are also there, madam. Photographs your lordship will find.
Exhibited as?
Exhibited as, madam. It is in the madam judgment, madam.
No, was it exhibited?
Yes, yes, it is exhibited, madam. They are exhibited.
Exhibited as?
As lordship kindly see.
What is the evidence of PWP? How PW4 says that? Let us see.
Yes, PW4. And lordship will find the recipient list of authorization. Compose authorization. Official report.
That has not been exhibited.
It is exhibited, man.
But in his statement, it is not there.
It is statement, it is not there, but it is exhibited, man. Probably not led, man.
Now, how will you answer it that mayor exhibit will document?
Man, yes, man, because exhibited, because it is before the court, man. Only thing that if it is not there in the sentence, man, but it has been exhibited, man. Because
no, the law is that mayor marking of exhibit is not sufficient. Proof of document is required.
Yes.
So he'll have to come and say that this is the document, this is the exhibit, and I know this or that. Simple like that.
Yes. Certificate of.
What is the exhibit? Give us the exhibit. Exhibit of photographs, which was taken before the magistrate. He has not said that these photographs were taken before the magistrate and magistrate has certified.
Exhibit, my lord, P6 PW.
Whether the entire seized materials were exhibited.
And,
no. If not, then photographs will be
Yeah, it
required.
has to be, man. Photograph is there, man.
No, photographs is there, but photographs you'll have to say, these are the photographs which was taken before the magistrate.
P11 uniform.
And magistrate has given a certificate. Certificate is exhibit so and so, so and so. Where is that? That is inventory.
Yes, and certificate is also.
What is inventory?
Yes.
But see, there one is inventory.
Yes.
Other is so far relating to the sample.
Yes.
Sample was taken in presence of magistrate.
But
now,
my lord, what I beg to submit, my lord, the inventory, my lord, it consists the inventory prepared and also
see, there is certain very important issues. See, if you go to the sample, just why I'm putting it, because as in the judgment, I'll have to answer it.
Yes.
If you come to page 83,
yes.
What the so far relating to correctness of inventory, it is fine.
Yes.
Okay. Inventory is the entire seized material, isn't it?
Yes.
Inventory is the entire seized material. That has been certified that yes, it is fine in the seal condition. I have got it.
Yes, ma'am.
Now, second is the list of sample.
Yes.
What is the list of sample? See, present it is to be sample is to be taken, representative sample in presence of the magistrate. In presence of the magistrate. What should be the certificate?
Certificate of my lord,
because that sample is treated to be an primary evidence.
Yes.
As a representative of the entire material.
Yes.
So magistrate says, yes, this is the sample I have taken from this.
Yes.
What the magistrate says here?
Yes.
Certified to be correct. What correct? List of sample.
Because
that it has been taken in presence of me. Where is that?
Because yes, it is there, my lord.
Where is that?
The section, because magistrate to whom an application is made to allow the application, as I have seen the satisfied above inventory as per seizure documents.
No, Mr. Goswami.
Yes.
One is inventory.
Yes.
Inventory is the whole material seized.
Yes.
Okay. After seizure, you will have to present it before the as early as possible before the magistrate and seek that it is certified.
Yes.
So magistrate will see and see your inventory and certify that yes, it is correct as per the inventory.
Yes.
Fine. This is one aspect.
Yes.
Second aspect is the magistrate, you'll have to take representative sample in presence of the magistrate,
Yes,
and magistrate will have to certify what?
Yes.
That these are the sample taken
Representative
in my
samples.
presence. Where
Yes.
is that certificate?
My lord, yes, that exactly that format, my lord. Your lordship.
Not necessary in the
Yeah.
format, forget about it.
Because
Where is the substantial compliance?
because my lord, when the sampling procedure has been laid down, my lord, by the notification, it says that, my lord, certificate, my application should be there as per annexure, my lord.
Yes, it is,
And-
it
and-
shall be allowed by the
And
magistrate,
my
as
lord,
well as
that is the format of application. And what after that, my lord, but when it is applied, my lord, it has to be allowed. Allowed and annexure 1 is the, my lord, inventory and the certificate as per section 52A. That is why I am stressing on this point, my lord.
Okay,
The
let's
gazette
understand.
notification.
Do you say that there is no necessity of certification of the magistrate,
Yes.
saying that these samples were taken in presence of me?
Because order will be there and also the certificate as per the, my lord.
Order will be there.
Yes.
Where is the order says here?
Yes.
Please flag mark the order.
Yes, order will be there and also, my because that order will be a part of the court and also
Okay,
the.
therefore, please,
also-
please
yes,
flag
I'll
mark the
flag
order.
mark the order. Yes. And also, my lord, since the annexure 1 has been complied with, my lord, and.
Annexure 1 prima facie you are satisfied. Okay, now coming three responsibilities of the magistrate.
Yes.
One is certifying the inventory.
Yes.
Second is taking the sample in
Yes.
magistrate's presence and a certification that it is taken in my presence.
Yes.
Third is that you'll have to take a photograph
Yes.
in presence of the magistrate,
Yes.
and magistrate is to certify the photograph that it is taken in my presence.
Yes.
So if these are satisfied,
Yes.
then even if it is a secondary evidence,
Yes.
a
Then also,
photograph,
my lord.
not the original materials
Yes.
are there, it
Yes,
is
yes.
the sample, whole inventory is not, because whole inventory is to be disposed under 52A. So just since nothing is there, it will be treated as the primary evidence, though it is not.
Though it's not.
Though it is not.
No, sir.
Why it will be used as primary evidence? On the basis of certification of
Yes.
magistrate.
Yes.
So therefore, this certification is very sacrosanct
Yes.
for the proof.
Yes.
That is what Supreme Court has said.
Yes.
That is their argument. They
Yes.
say that where is the certification that this is the sample taken? Where is the certification? No certification. They are saying where is the exhibit you have proved
Yes.
that this is the photographs of the day is so and so, and it was taken before you.
Yes. Now, my lord, yes, my page 71, my lord.
Page 71
Yes,
of the paper book.
paper book, my lord. Page, you'll also see the page 70. That is the application.
That we have seen.
Your application, your lordship will find para 2 as required under subsection 2 of 52A of Narcotic Drugs and Psychotropic Substance Act. I am hereby submitting the enclosed inventory of seized narcotic drug, psychotropic substance, controlling substance, or convenience at annexure 1 of and request to certify the correctness of the inventory. Permit taking in your presence photographs of the seized items in the inventory and certify such photographs as true, allowing drawing of representative samples in the presence, and to give disposal order for disposing seized NDPS exhibits after receiving the FSL. This is the application filed before the magistrate by the heir. Now your lordship will find page 71 are the photographs, my lord.
Who exhibited this? Exhibit
This is, my
P6.
lord, exhibit P5, PW4.
Exhibit P6. He has not made any statement that these are the exhibits.
Lordship.
How you address this?
Lordship, this is
See, Mr. Goswami.
lordship.
See, law is well settled
Lordship.
that mere marking as exhibit will not suffice. It is to be said that yes, these photographs was taken before the magistrate. This is the certificate of magistrate. Better ends there.
Yes.
No further things in required.
No further required, but this
Then they make a question. No,
Yes.
this is not the signature of magistrate. This is not the
Yes.
photo. They will have a chance to cross-examine.
Yes.
You have not even said that this is some magistrate has marked as an exhibit.
Because, but my lord,
No,
yes,
is
yes,
it a fact?
yes, my lord.
This,
Law
you
is law,
cannot
my lord.
improve.
We cannot
You
improve the what has been
improve the
done. my
facts,
lord.
what has been done.
What has
This is
been done, we
different.
cannot improve. my
Anyway,
lord.
okay, proceed now.
Yes. So,
So
and-
according to you, it was a substantive compliance when
Yes.
photographs were taken
Yes.
and magistrate is given and
And-
there is no cross-examination so far relating to the authenticity of such
Yes.
document and
No.
exhibits. Now
Because-
it is not a stage to raise all this
Yes,
objection.
because exhibits are, my lord, exhibits, when the exhibits are exhibited, my lord.
These
it is
exhibits
under-
were marked and it was accepted without objection.
Yes, man, that is my case, man.
Okay.
Because they have, these exhibits were.
You
on
note
the
it down, you give a note.
Yeah, I'm doing that. Yeah, these
Okay.
exhibits are.
Okay, that's fine.
Yes.
That is
And
that is
page-
your answer.
yes,
Now
page
what
7.
is the next? So according to you, these are complied with.
It is complied with, my lord, as per my lord saying. So if that is, we believe,
Your
my lord.
case is part is that section 50 or 42 or 41 is not necessary, body search and all, because
Yes.
it was a sudden.
It was a sudden.
But
and the-
there is no dispute as regards the authorization. Authorization is there, it is
It
exhibited.
is exhibited.
Possession is confirmed.
Confirmed.
Possession is confirmed, and therefore,
No.
then the section 52A has been substantially
Yes.
complied with,
Yes.
and no prejudice can be said to be
Yes,
caused
yes.
because they have not raised any disputes as regards to exhibit 5 and 6.
Yes, there is no
They-
dispute.
no
It's the matter cross examination.
No dispute. So therefore,
And moreover, my lord, the evidence of the scientific expert, my lord, whom it is not the evidence of the PW1, PW, my lord, prosecution side, my lord. It is a court witness, my lord. He was called for, my lord, and that, my lord, evidence.
he
is
said
being-
that I got in a sealed position.
He in a seal position, and also the facsimile is, my lord,
Intact.
as intact as a superintendent of police, my lord. And that fact that it was sent to the SP office, it came in the evidence of PW, one of the PW I have seen, my lord, because after seizure for sending to FSL, it was sent to SP office, my lord, and SP has made send it to the FSL record. And from the evidence of, my lord, scientific expert, my lord, it says that yes, we have received this from SP office, and the facsimile
That's
is
not disputed.
yes.
There is no argument
Yes,
to that effect also.
Yes, yes. Since it is not disputed, my lord, FSL is not challenged, my lord. That is very important.
So it
aspect,
was
my lord.
established that this, when according to you, the entire saying has been established that it is proved that these are the material inventory is correct,
Yes.
sampling is correct,
Yes.
photographs is exhibited without objection, and therefore forensic is established. So therefore,
Yes.
whole chain is established, and in view of that presumption, that you have discharged the foundational
Yes,
discharge, and he has failed.
And the PW's, my lord, and Caesar witness also supporting, my lord. And one yellow circle can. VDP second.
VDP second.
Yes,
I've
he is
seen that. That we
supporting.
have already
Yes.
recorded all
Yes,
this evidence.
that is why I am not reading it, my lord. So, my, and another aspect, my lord, he had failed to, my lord, reverse the burden, my lord.
That
He
is
was-
what I'm saying.
Yes,
That when you have proved it,
How, my
his
lord?
reversal was upon him. He has
Alhamdulillah,
not.
How, why I'm saying so, my lord? In 313, my lord, 313 was taken twice, my lord. First, after the prosecution witness, thereafter, after, my lord, the examination of court
Defense.
witnesses, my
Court
lord.
is okay.
Again, he was asked, my then also, my lord, he has not
He has
said
no
anything.
explanation
No
except denial.
Or anything, only a simple denial, my lord. So he has failed to, my lord, discharge his burden, my lord. That is it. And another, this is regarding sampling, my lord. And in the division bench, my lord, there, my lord, some discrepancies were there that the certificate is not done there, my lord. And the sampling, my lord, yes, regarding there is doubt in sampling regarding PWs also, there are some discrepancies in the evidence of PW. And my lord, other things, my lord. And one thing has been discussed there that the contraband that has not been exhibited in the later part, my lord, since there is no order. But that has been, my lord, though the reliable, my lord, honorable, my lord, division bench, my lord, has relied on two judgment, my lord, Nuraga and another one thing, my lord.
No, Nuraga, it says that it is better when the entire matter is exhibited.
Exhibited.
But when this is not done,
Mm.
therefore, the provision of section 52 A is to be scrupulously followed.
Followed.
Because without a primary evidence, the sample are being
Yes,
accepted as
Yes.
primary evidence.
yes. On that ground, my lord, on this judgment, my lord.
Which judgment?
Okay, my lord, that there, my lord, in this judgment, my lord. Here, my lord. Mark the 11 paragraphs, my lord,
Mm.
where it is, we discuss the Noor case and other cases, my lord.
Mm.
And after that, it has come to the conclusion, man. Then.
This
on-
judgment.
Yes, only, my lord, the fact that the entire contravention is not exhibited, it is not a ground for acquittal.
Mm.
That is, because they have very finely discussed those judgments. my lord. And the division bench has
You
retired,
relied on this judgment in other case also.
my lord, that is.
More or less similar, therefore,
Similar.
deliver this
Yes,
judgment.
Yes, yes, that judgment is passed or not, I don't know, it's not. This is, and another thing, my lord. That, what the. What will this mean? In the division bench judgment, my lord, there, my lord, one of the PW1, he said the photographs are taken by him, my lord.
Understand?
That is what the discrepancy occurs, man. That is also one part. When I'm, my lord, they're saying the facts, my lord, on the backdrop of which my division bench judgment has been passed.
Therefore,
So it
ultimately,
does not.
law
squarely-
is well settled.
only the
Only
law part.
whether that has been followed in given
Yes.
case of the each case.
Yes,
That's all.
facts are
Now,
completely
what do you
different.
say about that commercial quantity and
Commercial quantity regarding the section, my lord.
section?
Yes, my lord. This is a very interesting, my lord.
Because
Here, it is as per my learned, my friend, my lord.
Mm.
It is, my lord, should have been given under 21C, but wrongly given 22C. But both this section covers the, my lord, one is for manufactured drugs, another is psychotropic substance. my lord. But in both cases, my lord, the punishment is same, my lord. And both cases is a commercial.
It is not a commercial quantity, it is a smaller quantity, therefore lesser punishment.
No, my lord, it is not. It says that, my lord.
No,
It says-
he has written somewhere.
Because the harassings, my lord, then I will rely on the harassings case, my lord. Lordship will kindly come to the paper book. It is, my lord, seizure of 11 numbers of cough syrups, my lord. Then it goes above 1 kg, my lord. When 1 kg is the commercial quantity, my lord.
So he says the total weight of 48 numbers of tablets is 2.640
Yes, my that part
grams.
I am leaving because my those are not covered by commercial quantity, but the cough syrups, man, there are 3 types of contraband. What I have, that is what I have.
Okay, you want to say
Yes, even if,
that
my lord,
nitrozepam
yes,
may be
even if, my lord,
maybe not small quantity, but so far relating to the cough
cough
syrup,
syrups,
that
it
is
is a commercial quantity, man.
okay.
The lordship will kindly come to, for that, my lord, I am relying on that, my lord, harassing judgment, that is 2020, my lord, 20 SCC 272, my lord. 272.
272. Yes.
And let it be my 2020 Supreme SC 320. That
Can you
is
give
my-
me a copy?
Yes, my lord, but no, my lord, the copy.
2020 volume 20.
Yes, and also kindly come to the judgment part, my lord, 46, page 46 of the paper book.
Page 46.
Lordship.
Yes.
Para 33, my lord.
Yes.
Below, my lord. The Honorable Supreme Court of India in the case of harassing versus Union of India.
Okay,
while-
20 SC to okay,
Yes,
okay, fine.
overruling the judgment of E. Michael Russ. E. Michael Russ judgment is, your lordship, aware that he said that only the quantity that is proved to be the contraband is should be taken into account. But the harassing judgment, my lord, the division constitution bench has said that no, the entire quantity has to be taken into entire. My lord, if the considered bottle is there, entire content has to be. And that is, my lord, your lordship will see page 10, my lord. In case of seizure of mixture of drugs. In case of seizure of mixture of drugs or psychotropic substance with one or more neutral substances, quantity of neutral substance is not to be excluded and to be taken into consideration along with actual content by weight of the offending drug while determining the small or commercial quantity of the narcotic drugs or psychotropic substance. There is no dispute as regards that, my lord. So now, my lord, it is 11 numbers of cough syrup, my lord. It is more than 1 kg, my lord.
Yes.
Yes. So this is that is there. And another thing raised, my lord, that the charges were framed on under section 21, section 22 C. So they have been under section 21 C, my lord. Even assuming that, my lord,
That is not a fatal thing because
it's not a fatal
higher charges you
Yes.
can make, you can give lower
Yes,
permission.
and
But if
here-
in case of lower, you cannot give higher.
higher. And here, my lord, it is identical, my lord. Same punishment is accorded to the in both these sections, my
That
lord.
is not pressed.
So, my
That,
lord,
that arguments are not pressed, which we will
yes,
not
my
delete.
lord, because it is in the written
Argument, but he
Yes.
said he will rely, his
lordship can-
argument will confine to paragraph 4 and 5 only.
Yes, my lord. Your lordship, in the written argument I have found, my lord.
In written argument, I have marked it.
Yes.
Mr. Datta submits that he will confine his argument to paragraph 4 and 5.
Yes. Lordship can see the,
So therefore,
yes, my lord.
in 4, he relies on the division bench
Yes.
judgment to say violation of 52A. And in 5, he relies on the 22 and C
22 and
commercial.
22,
That's all.
that is commercial.
That's it.
That is yes. So
That-
it has to be, if we assume that it has to be under 22C, but at best, the honorable court can alter it to section 21C, if it is so. And on that, my lord, I have a judgment, my lord.
Yes, give us.
This is going in the ratio, my lord. This is a judgment passed by
Rajasthan.
Rajasthan, my lord. Lordship, may kindly come to page para 15, my lord.
Para.
This is regarding your lordship has already stated. This is may not be required. This is the Balbir Singh judgment where, my lord, when section 50 does not attract because the recovery is from para 15, it is discussed. On plain reading, section 3 would not come into play only in the case of search of a person. So it is distinguished. That is your lordship has already indicated, my lord. And also, but I want to rely on paragraph 19, my lord. May I read, my lord? The last contention somewhat faintly urged by the conviction under section 22 is illegal inasmuch as article in question is not a psychotropic substance. It is not denied that the seized substance answers the definition of manufactured drug being an opium derivative containing acetyl morphine, and therefore the appropriate section providing for punishment is section 21. The punishments prescribed under section 21 and 22 are the same. By reason of citing of wrong section, we do not think that appellants were handicapped from meeting the case against them or otherwise suffer any prejudice. The trial and conviction cannot therefore be set aside in this score. Then your lordship may kindly come to page 21, para 21. Last para minus. Consequently, criminal appeal is dismissed. Criminal appeal number such and such is allowed to the extent under 307, he was also convicted of 307, that has been allowed. Further, his conviction under section 22 of NDPS Act is altered to one under section 21 of the Act, and the sentence shall remain the same. So it's a minor, only this cases that has been minor.
You want to?
Yeah, I will give it because you lost.
Okay, yes. If senior want to respond to it, or we'll make it Chevy.
Hello, may I submit one thing regarding section 21 and 22? Hello. Regarding section 22, it relates to the provision for punishment in regards to, with regards to psychotropic substance only, my lord. It is clearly stated there in section 22.
So we'll conclude today. Your
Yes.
senior will not address.
Because that is what only these points only, my lord. Because I have stated.
That's
only-
why we are pressing for the, that pensital cough syrup and escap cough syrup, it doesn't come under the definition of manufactured drugs, my lord. For this reason, my lord, because this section 22 specifically provides for punishment for contravention in relation to psychotropic substances. And section 21, it relates to punishment for contravention in relation to manufactured drugs and preparation, my lord. And pensital cough syrup
Is a manufactured drug.
manufactured drug. So it shall come under section 21 if it comes, my lord. And regarding the psychotropic substance, the recovered psychotropic substance is only 2.640 gram, my lord. So
That is
small quantity, my
small
lord.
quantity.
Yes, my lord. So for that reason, my lord, since it is a whether it comes under manufactured drugs or not, the pensital cough syrup and the escap, regarding the quantity of codeine present in those cough syrups, for that reason, my lord, we are submitting regarding the provisions of the standing order of 1985, which provides in.
But these are not argued on the last occasion.
Yes, my lord, because we are not going to that part anymore. It was submitted.
If they're not going. If you start,
my
then
lord.
you will have to give him a chance again
Yes, my
to
lord.
argue on that. Then you will have to have a reply. So your senior said we are confined to 2 points only, 4 and 5.
Because he has given the argument and I have only written.
And regarding, my lord, these certificates, where 2 certificates are required, my lord.
Where
for-
is that 2 separate certificates are required?
My lord, it is provided in the form itself. One for inventory, my lord.
Where is that? Let us see. In the annexer?
Lord, in
Which annexer? In your written argument?
no, my lord,
the
from
book, my lord, is.
we are submitting from both.
Which provision?
Regarding the survey inventory of seized material, my lord, and one for
No,
certifying.
what is the provision?
Under provision 52A.
No, you are reading what? Any form, any appendix, any section, any rule?
It is under
What is his readings? Let's see.
this one. Certificate
Oh,
from.
yes, ma'am. Page 270, he is referring to that, that I
Certificates,
have
my lord.
referred, my lord.
That annexer.
Annexer.
This is part of the notification
Yes.
issued under
And that is.
50 P. That is
52A.
with us.
Yes, that is.
Which form?
That is form number 4, that is.
Form number 4.
That is the form number 4.
Let us see. Form number 4 is not here.
That is a part of the, my lord, notification. my lord.
Notification,
Same,
This is the notification.
same, my lord.
He has annexed. Are you
Yes.
having a form
Yeah,
number 4?
this is the under the rules of 22. But these rules may not be, my lord, applicable because these rules came in the December 2022. And the case is prior to that.
That is why.
That is why I'm referring to the notification, ma'am.
In earlier rule also it was there, my lord. But that certification for correctness of the photograph and sample drawn in presence of the magistrate, because it has to be.
No, Mr. Counsel, please clarify.
Yes, my lord.
These notifications are issued in exercise of power under section 52A.
Yes, my lord.
Yes, Mr. Datta, you are here. Section 52A. Okay.
Yes.
Now, that just I want to have a clarification as regards that separate certifications.
Yes.
That is what I want.
Yes, but
Yes.
written submission. I filed one written submission.
I'm out, that is, I'm having this.
And that my lord, judgment says, my lord,
Which, that division bench.
division bench.
That is what I have asked, where is that ratio laid down?
Paragraph 37.
Paragraph?
37.
Paragraph 37, when a documentary evidence.
Yeah. On the appendix. Bas. I'm sorry, my lord, paragraph 41, the ratio has been laid, my lord.
Paragraph 41.
Paragraph 41. On evaluation of the evidence produced by the magistrate, by the prosecution, my lord. Last 4 lines of that paragraph, my lord. Last 5 lines, my lord.
There is clear doubt.
Now, in the absence of primary evidence in the
Oh,
above
yeah.
forms, the other evidence led by the prosecution in the present case, as enumerated above, cannot be termed as valid piece of primary evidence.
That's right.
Yes.
That's why what is his case is that in his case, what he has argued. That's why we wanted him whether Mr. Datta will respond or will close it for CAV. What I'm saying is he is referring to page 81 of the paper book. And he submits that this is the exactly the form prescribed in the notification dated 2015, whereby inventory was certified.
No, exactly no.
That is his argument.
No, because to my understanding, according to this book, my lord, there are 3 certificates, 2 certificates are required. My lord. One is, my lord, it starts as whereas the above officer has applied before me for, my lord, inventory. And the second, my lord, sampling. For sampling, it is very much required, my lord. It says, my lord, I. It starts as I, my lord.
Where do you get that?
My lord, I allow the above application and this.
This is part of what?
Yes, part of.
Part of?
Form 5. Form 5.
Form 5.
Yes, fine.
Form 5 is not part of your notification.
No, my lord, that is this, that my learned senior friend is, my lord, referring, my lord. This is the rules of 2022, my lord.
No.
You know,
No. Yo.
Yeah, to say.
No.
That is what he is arguing. That's why we want that.
No. That I'll clear, my lord. My written submission, paragraph 2, my lord.
Paragraph 2. Yes.
Paragraph 2. In the present case, the date of occurrence was 28/01/22. The new rule came into force from December 22. I am not on that matter. Thus, on the date of occurrence.
2015 was applicable. No
Yes,
doubt about it.
2015 was
So
applicable.
therefore you have annexed the 2015 also.
Yeah, that's why I have annexed.
Huh.
Let him reply to the 2015 rule.
I have stated before 2015 rule, I have annexed.
What he said that the certification at page 81, according to him, exactly in terms of the prescription made in annexer 1 of the notification.
Yes.
According to him.
Yes.
That is what he has said. Now annexer 1 is at page 40 of your written argument.
Yes, ma'am.
Huh.
And page 42 is the certificate that is not available, man. Econ certificate.
That according to him, that certificate is the page 82.
Page 81.
Yes.
Page 81 does the details.
Details and
And
page
page 82
82
is the certification
Yes,
of
but
the
it is for the inventory.
inventory.
Where is the certificate of sampling?
That is what I am asking.
is-
He is saying
that is-
certificate of sampling.
Yes, madam.
He says
Ah.
that this is the list of sample, this is the only in the body of the certificate.
Yes.
That is what I am asking, that whether a separate certificate will be required.
Yes.
That will be required in terms of, according to you, in terms of
15 notification.
uh,
Your lordship will kindly come to page 42 of the
Written submission, page 40.
okay.
That certificate is not there. ID আমি বলেছিলাম that is not available.
Yes.
That is what I am asking, that this is this is even exhibit P11,
Yes.
exhibit P12 is only a certificate that contains no certification of this sampling.
Which is very much required under the.
Because to be a primary, because what do you mean by sampling? Sampling means the representative of the whole material.
Yes.
Whole material is the primary evidence.
Yes.
Since whole material is to be disposed of, so therefore a sampling is permitted and it is allowed to be used as a primary evidence, though it is
Yes.
not a primary evidence.
Yes.
So therefore, that's what I had used, the certificate will be a sacrosanct thing.
Yes, ma'am.
That is not here.
Yes. Subsection 3 of 52A, man, that is the same, my lord.
But suppose assuming,
but my lord-
assuming for a moment,
But the-
there is substantial compliance.
Yes,
In page 82 also, there is no mention of the sampling,
yes, it's not, only inventory.
only inventory.
Yes. ma'am.
So had it been that sampling is given here, we would have, suppose for compliance, that is there is substantial, we'll go for the
Yes,
principle
what-
of substantial compliance.
Yes.
But here is
Whether-
non-compliance.
Whether, my lord, if we assume, my lord, it is the, my lord, I will not say the fault of the, my lord, magistrate, whether for that, my lord.
No, whose fault we do
my-
not know.
Because, my lord, your lordship will
See,
see.
one aspect, it is clear, there is no doubt in the mind of this court that in certain cases, in Supreme
your
Court Supreme Court has said that when there is substantial compliance and which has not prejudiced the right of the accused, there are something here and there will not vitiate the trial.
Yes.
But when there is total non-compliance, it is like, it is twofold.
Because, my lord,
Division bench judgment.
Forget
suffice.
about that division
Yes,
bench
ma'am.
for the time being.
because, my lord,
My lord, why I am saying the division bench, my lord? The division bench has, my lord, interpreted a judgment of the Supreme Court.
Huh.
That, my lord, Mangilal.
Mangilal and these
Yes,
other
our division bench came to a conclusion that that certificate, that notification 2015 was not brought before the court.
2015 applicable, I have stated that.
that he is not questioned.
I am not questioning.
So therefore, he wanted to say, this question I have already put him.
Yes.
He want to say that since below the sampling, there is a certification of that will suffice. But that is what I have asked. That's what is required to be certified. That these are the sample taken from this inventory in presence of me.
Yes.
That is, then only it will give a status of primary evidence. Otherwise not.
Your lordship will, then I am also relying on, my lord, page 70 of the paper book, my lord, where,
Okay.
my lord, the
I have made an application.
Mayo has made an application, my lord.
That is a different.
No,
thing.
Because
I
the-
has made an
application and everything is before the, my lord, learned trial court, my lord. Learned-
That's true. But
Then, my lord,
do you say that
Yes.
when there everything is done but certificate is not
Yes,
there,
but-
it will suffice?
Yes.
We do not think. Otherwise, the legislature and the court would not have
lordship
said,
will see that.
because we must be very careful.
Photographs are there, list of samples are there made.
That is there, but no
Yes.
certificate. They have even not cross-examined you. Will
Yes,
not
they have-
cross-examine.
Yes, my lord,
Because basically
Because-
honors is upon you.
yes. And your lordship will see, my lord, that
Moreover, my lord, 10
there is
bottles.
no any
That-
cross-examination
that-
from that part. my lord.
Only 10 bottles, my lord. That has to be seen.
Yes, my lord, at this time, 10 bottles, my lord.
No, if you say that let the conviction remain
No,
on.
no, I am just pointing it out.
No, then will not go. If we are entering into a merit, we'll
Yes,
decide.
why not, my lord?
Yes,
Yeah.
we'll decide it.
Right.
That's why we are
Yes.
spend so much of time.
Yes,
Otherwise, we could have done in the day one.
Yes, man.
That's all.
Suffice, my lord. Everything is.
You want to give a note? Let
Lord,
it be.
yeah.
Hearing concluded. Judgment reserved. In the meantime, the learned counsel for the petitioner, additional public prosecutor may give his written note of
Lord,
argument.
date not.
We'll
Not,
try to
just
give you
because-
next week. We'll
so
try.
Just only bullet points. my-
Bullet points, that's all.
Your Lordship actually
now what happens-
flag mark there. Yes.
That's because of for dictating
Yes,
the
yes,
judgment.
Now what happens, my lord? So far, my lord, this brown sugar is concerned. It is generally recovered from soap boxes. So when they take before the magistrate, my lord, they mix it up. That is also wrong. Now specifically the rule says every packet. my lord.
Yes, next.
I am obliged.
Please, your Lordship.
Yes, you wanted to rely on some judgments.
Lordship, he had relied on two judgments. One is Technomont, that is of Supreme Court Lordship, in which the virus of they had challenged the section 62(5) of Punjab VAT Act Lordship, which is similar to our section 79(5) Lordship. Now, Supreme Court said that paying a preliminary pre-deposit, that condition, it is a statutory thing, you have to fulfill that. But when this court, but in Supreme Court has also held, Lordship will kindly come to page. Last
Here
page.
in basically subject to what my subject to relation here, the provision itself was under challenge
Yes.
for deposit of certain amount. That was upheld.
That was upheld, but Supreme Court said that in proper cases, if because the case was for waiver of that amount. So Supreme Court said that in appropriate cases, Reed Court can see whether actually they are in financial difficulty or the amount.
Where is that paragraph?
That paragraph is paragraph 27, Lordship. 2021 12 SSC, Lord.
Paragraph
7, Lordship. Last page.
Hmm.
Please, small observation, Lordship.
Yes, where is that?
Lordship, paragraph 27. As stated in P. Lakshmi Devi and her Devi and Asnani, in genuine cases of hardship, recourse would still be open to the person concerned. However, it would be completely a different thing to say that the appellate authority itself can grant such relief. As stated in Shyam Kishore, any such exercise would make the provision itself unworkable and render the statutory intendment negatory. Lordship, in Supreme Court's observation is that appellate authority to whom we go, they do not have power.
No power. Now,
They do not have power.
genuine cases hardship recourse would still open to the person concerned. What is that recourse?
Recourse is to the Reed Court.
Where is
Lordship. And JSB or judgment has made it clarified, Lordship. Division bench.
Which judgment? JSB Cement.
Yes, JSB Cement, Lordship.
Okay, what it says?
Lordship, from paragraph 9.
Paragraph?
May be allowed to read, Lordship, from paragraph 9.
Paragraph 9.
Yes.
Yes.
After considering Technomont, this observation has come, Lordship.
Hmm.
The import and effect of the judgment rendered by the Honorable Supreme Court of India is that in case the requirement of pre-deposit is found to be arbitrary and exorbitant, only then the writ court would interfere. Considering the law laid down by the Honorable Supreme Court of India, portion of which has been extracted herein above, we are of the considered view that paucity of funds available with the petitioner would not per se be a ground for interference in this regard. In peculiar facts and circumstances of this case,
particularly because statutory provision requires a pre-deposit of 25%. Learned counsel for the petitioner contends that the writ court is also a court of equity. The period for deposit of 25% of the amount has been extended by 2 weeks by the respondent authority. The said period be extended. The writ court has again extended the period for pre-deposit. Maybe this period is shorter and my period for depositing, because the amount was so exorbitant, I became little late in depositing the whole amount. I am not, Lordship, in this case, I am not asking for a waiver of the amount. I have already deposited the amount. But the time has elapsed.
Yes, Mr. Chaudhary. See, law is well settled. This is a statutory deposit. It is to be given. The appellate authority will have no power to give any relaxation. And therefore, appellate authority is right in not accepting the statutory deposit. Now, their argument is that this court exercising power under 2226 is having a power to extend that period, but in this case, they have even deposited
32%.
in the meantime. Therefore, this is a case where equitable relief can be granted to them by asking to admit the appeal and hear this matter.
And that way, Lordship, one submission, Lordship, revenue will not lose anything.
Lordship, it's true that under Article 226, Lordship.
Division bench has in fact
Division bench
has extended. In our case, we are already deposited. There is no question of extension.
But Lordship, the deposit was made in spite of a repeated notice. Till the time of
deposit is made.
Yes, Lordship, till the time of dismissal of the appeal due to non-deposit of the pre-deposit, Lordship, they have not even touched the 25%. Much later on, they have deposited about 32% of the disputed tax amount. Lordship will have Lordship will have to consider the time period. Otherwise,
you have deposited how much?
32% by this time.
Okay, tell us the date. Date of appeal.
Sure.
Date of filing the appeal.
Because Lordship, there is a time period also.
13/6 to
Impugn order.
13/6, 2012.
13/6, 2012.
2012.
And then
Lordship, after that we have made the payments, Lordship.
Appeal within a period of
60 days.
Now, when have you filed the appeal?
Appeal was filed in time, Lordship. Appeal was not filed.
That is no problem on that. Appeal preferred within time. Within time, but no deposit.
No deposit. So at the time of
Now, when it was intimated to you?
Lordship, the amount was 3.5 crores, so it took some time. And the chart, Lordship, will find at page 83, Lordship.
Page 83.
Page 83, Lordship. Since 2012, we have been paying. 12, 13, 14. Till the filing of the writ petition, Lordship, this is 32%, Lordship.
When the order was dismissed?
Dismissed, Lordship, that
when
is
the appeal was
order.
dismissed?
Page 78, Lordship. That is the order which I just now gave, Lordship.
Page 78?
Yes, yes.
No, you have written 83 details of payment deposit.
83 is payment details.
When is the order, impugned order?
Impugned order is at page 78, Lordship.
78.
13/6/2012.
Page 78.
In paragraph 2, Lordship, they have recorded also that a request for extension of time for deposit of 25% of the disputed tax and interest for another 2 months is made.
Ms. Gop, learned counsel for the petitioner, also Mr. B. Chaudhary, learned standing counsel for the
Finance and Taxation.
Finance and Taxation Department. The petitioner was assessed to tax under Assam Value Added Tax for the assessment year 2006-2007, 2007-2008, and 2008-2009. Aggrieved by such assessment, the petitioner challenged the order of the original authority, before the Commissioner of Taxes, within bracket appeals, Guwahati. Full stop. The it is under 79.5 deposit.
79, yes.
Yes. So in terms of section 79 within bracket 5 of the Assam Value Added Tax Act, what is the year?
2003.
2003. An appeal is and can be entertained by the appellate authority only on deposit of 25% of the disputed tax and interest, and and after proof of payment thereof. Full stop. As the petitioner failed to deposit 25% of the assessed amount, how many appeals are there? Three common judges. All the three appeals preferred by the petitioners as appellant were dismissed by an order dated 13/6/2012. Being aggrieved, no, you have made this payment before filing of this writ petition.
Yes, yes.
In the meantime, it was dismissed on which date?
It was
13/6/2012.
13/6/2012.
Thereafter, the petitioner from the period of 21/6/2012 to 22/11/2016 deposited on different occasions, totaling an amount of rupees 363,05140, being the 32% of the
Disputed
disputed tax assessed,
interest penalty together.
tax, interest and penalty assessed, interest and penalty assessed. Thereafter, the petitioner has approached this court.
One small. Lordship, after that we approached the Commissioner of Taxes also, that we have made the
Full stop.
payment. Kindly.
Thereafter, the petitioner also approached the Commissioner of Taxes, intimating that
Consider our payment.
requesting the former to consider the case of the petitioner and to hear the appeal by their communication dated 23/6/2016. Is that it?
Yes.
23/6/2016, which was duly received in the office of the Commissioner of Taxes. However, having no response, the petitioner has approached this court.
That is rejected, Lordship.
Where is that?
That is rejected, Lordship. Affidavit says that. The affidavit says that because 82 it was time barred, Lordship.
Thereafter, the petitioner has approached this court. Full stop. The respondent tax department has filed an affidavit and took a stand that the commissioner has also rejected the representation of the petitioner dated 23/6/2016. MS Gop, learned counsel for the petitioner, relying on the decision of Technimont No, not Technimont, which you are relying? JSB Cement Limited LLP versus State of Assam and others reported in 2019 SCC Online Guwahati 5983 and the decision of the Honorable Apex Court in Technimont Private Limited versus State of Punjab and others reported in 2021 12 SCC 477 argues that applying the equitable principle, a direction be issued to the appellate authority to hear the appeal of the petitioner as the petitioner has already made the deposit of 25% as mandated under section 79 within bracket 5 of the Act. Full stop. Per contra, Mr. Chaudhuri, learned counsel for the Respondent Taxation Department, submits that the appellate authority has not committed any illegality, which is any illegality that is, and therefore the decision may not be interfered by this court in exercise of power under Article 226 of the Constitution of India. Referring to the decision of Technimont Private Limited, Mr. Chaudhuri submits that the Honorable Apex Court in no unambiguity held that the appellate authority shall not have power to waive such a statutory prescription of deposit of 25%, and therefore there is no illegality, and therefore no illegality has been committed by the appellate authority, and that being the position, this court may not like to exercise its writ of certiorari jurisdiction in interfering with such a decision. That is your case. Full stop. We have given anxious considerations to the arguments advanced by the learned counsel for the parties. Just a minute. This is counsel for the parties. Referring to the earlier decision, the Honorable Apex Court in the case of Technimont within bracket Supra, no doubt has laid down a proposition that the appellate authority shall not be within jurisdiction to give a concession, dehorse the statutory prescription of deposit of statutory deposit as a condition precedent for entertaining an appeal. However, referring to the earlier decision of the Honorable Apex Court in P. Lakshmi Devi, what is the citation of P. Lakshmi Devi? Referring to the earlier decision of the Honorable Apex Court in the case of State of AP versus P. Lakshmi Devi, reported in 2008 4 SCC 720 and Hardevi Ansai versus State of Rajasthan, reported in 2012 2011 14 SCC 160. The Honorable Apex Court held that in genuine cases of hard course, the petitioner can take the recourse would be open to the person concerned. However, it would be completely a different thing to say that the appellate authority itself can grant such a relief. For the reason that such exercise would make the provision itself unworkable and render the statutory indentment nugatory. Full stop. Such determination was dealt by by a division bench in JSB Cement LLP within bracket Supra and Supra. Supra held that when in case of requirement of pre-deposit is found to be arbitrary or exorbitant, only then the rate court can interfere. And accordingly, applying the principle of equity, the division bench extended the time of deposit of 20% of the statutory deposit under section 79 within bracket 5 of the Act 2003 and directed the respondent to hear the matter on appeal. Full stop. In the considered opinion of this court, the principle of equity as envisaged in the judgments of the Honorable Apex Court as well as of the division bench shall also be applicable in the given facts of the present case, more particularly in a situation that in the present case, the statutory deposit has already been made. Full stop. This court, though, cannot find fault with the appellate authority in non-entertaining the appeal due to non-adherence, non-compliance of section 79 within bracket 5 of the Act 2003. However, this court in exercise of its power under Article 226 in the given facts of the present case is inclined to grant the benefit of hearing to the petitioner, more particularly in the given facts of the case that the statutory deposit has already been made. Full stop. Accordingly, the present writ petition stands allowed by setting aside and quashing the impugn
Dismissal order 13-6
order dated so and so. However, it is made clear that this court has not entered into the merit of such determination. Rather, same is set aside only on the ground for a fresh hearing. Full stop. Accordingly, in the aforesaid term, writ petitions stands allowed. The petitioner shall appear before the appellate authority on
within this month.
Give a date.
September. 27 September.
Appellate authority on 27th of September 2024 along with a copy of this order passed today, and on such appearance the appellate authority shall afresh take the matter on hearing on a date the appellate authority may convenient to the appellate authority. Full stop. It is made clear that if the petitioner do not enter an appearance on the said date, the order that has been set aside shall revive.
That revision dismissal also is there in the writ petition.
Revision.
Yes, that
Against that.
before the commissioner which we applied, that dismissal order is at page 90. Lord.
I said that the revision petition was filed before the commissioner. Huh?
That was rejected.
Just you write it down while correcting the order. I'll give. The revision filed before the commissioner was also dismissed, rejected by an order dated
13-10-2016.
13-10-2016.
That also may be set as.
Okay. This will also be set aside. Which are the writ petitions?
Only one.
There are one means these are three petitioners.
One petition for the 3 assessment years.
3 assessments. Yes.
Lordship, my name may also be reflected
Okay.
in the order.
Yeah.
Much obliged.
Yes,
Lordship,
Kolka,
similar-
what is this?
Lordship, similar litigation was heard on 16/7/2024, Lordship, and that litigation was sell out. But in this litigation, the effective order was passed on only because of the fact that there's a certain difference is that in this case, Lordship.
Where is
here,
that order?
Lordship,
What are the issues here?
Article 243Q of the Constitution, Lordship, provides for the constitution of municipality areas. Lordship. And 334 of the Assam Municipal Acts provides for the constitution of notified areas. So we are agreed by the inclusion of the 53 numbers of that of the
Belonging to company.
BVFCL township under the proposed constitution of the township area. Lordship, the Article 243.
So that way, now what is the difference between two cases?
Only difference, Lordship, that in this case, Lordship, we have submitted our objection and pursuant thereof a hearing was conducted, Lordship.
In that case, that was not there.
Not there. And in this case, speaking order was also part without having any findings, Lordship. Lordship, if Lordship peruse the speaking order that was annexed
Okay,
by the
not today then. It will take some time.
Thursday. Tuesday,
Yes, this can be.
Thursday.
Thursday not possible. Many cases are fixed.
Hearing day, Lordship.
19th. Okay. As agreed to by the Learned Council for the parties, list this matter on 19th of September.
Lordship, any date after 19.
Give a date.
Hearing day, Lordship, because 19.
24th. 24th of September.
Obliged.
Wait, please.
Possible.
Yes, today.
That Karbi Anglong.
Sometimes it
Lima
today,
Assam.
today weather is
Lima
also.
Assam.
Lima Assam, Lima Assam, not
My lord, only
Also
thing
other
is
day.
that, my lord, as per the affidavit filed by National Highway, my lord, it was, your lordship, kindly see one thing I want to point out, my lord. Page 84, my lord.
Tell us.
The letter was
You
written
want to
by
argue
the,
matter? Argue matter. Lordship.
no, only one point, my lord.
1 point. Next day you tell him.
Point regarding the, my lord, revenue authority responsibility, my lord. I'm not on the National Highway. As per page 84, my lord, revenue, National Highway returned to the Revenue Secretary. Whether our case can be reviewed to claim of the petitioner. Now, in that regard, my lord, the taking into account the inquiry report, my lord, submitted by the earlier by the in the year 2017. Let the Revenue Authority, my lord, my lord, my lord, inform the court, my lord, regarding the my lord, regarding the quantum of compensation to which the petitioner case can be considered on, because
Anything determined?
My lord, actually, that they submitted this matter only, not only him.
No, we understand that.
This was only already we have sent. Though initial stage, I have requested him, you go and approach. As they have not gone, matter is pending before reasonable. I insisted my officer, you place this along with affidavit or along with this petition and names and forward to this department. So that their names can also can include.
Their names are forwarded.
Their names have been forwarded.
Anyway, now forwarded. Now see, situation is this, that there are damages to them is an admitted position.
It is admitted position.
There was an inquiry by the state.
Yes,
Nobody has disputed.
No
Even
question.
you are willing to think over
Yes,
whether
but-
we can pay.
But who will pay? That was the question was
That was
coming.
the
That is
question.
why, because that contractor was from outside, he has left long back. We cannot call them. No job is left. That is why ultimately Union Minister had taken up with our minister that 86.3 crore will come. That is a decision as per that notification is done. They keep on deciding because these are
Now who will determine the individual compensation?
that is special committees constituted.
before that, my lord, Revenue Secretary should give an.
Revenue Secretary is the party there.
No. See, Mr. Borua, we are not hearing today.
Yes,
But certain, without going to the matter, certain vital issues are there.
Yes,
Suppose it is a damage caused by everybody to many a person, not only you.
Many a person.
Then if they have constituted a committee saying that we'll assess the
No, committee has not been considered by National Highway.
And we are.
Listen to listen. This is not your business. What is your business? Your business is that I have been got damage. I want money. Now, next question is who will determine the assess the compensation?
Case has not been taken up, my lord. That is the.
It isn't forwarded, na, now.
They are now.
You are not inclined to go to them.
Yes.
You are
When-
not interested to go
Not
to them.
interested
And
to
this
go.
court cannot read petition.
Our
Even if we held that there is a damage to you, we cannot determine the
But
compensation.
Here only.
Compensation is to be determined by an authority, either
Yes,
the
yes, yes,
collector.
yes.
Collector will have to
Yes,
decision.
Yes, that is the thing.
Revenue. If
Revenue.
they admit that here there are damage, we are considering. Whereas they are.
Revenue Secretary is the one of the parties. Not only 1 crore, my lord, 86.
No, not only revenue secretary.
All parties are there.
Who decides? Let us have an, who will inquire and complete the damage.
Yes, sir.
And that's all.
The committee is there. Yes.
2024.
That's all. But individually, we cannot make a assessment who, what is
Otherwise,
your damage.
our case is strict liability. Madam. Then I can enter into merit, madam.
My lord, may I, only one point. What committee is there? Damage Assessment Committee, Principal Secretary come, Revenue Secretary. Then the NS Haflong.
Strict liability,
The-
suppose we hold,
the
that there is a strict liability.
the- the-
What is, how, who, what will be the tortious liability? We agree strict, everything is done. What should be the damages?
Strict liability, madam, liability causing injury to the, for their.
So that we understand, what, how will you quantify?
As per the, well, this enquiry report, they will revenue, that is why I'm saying revenue secretary will quantify this is the amount.
They will quantify. because
But that has
is
not
a-
been accepted by
But
national
my
highway.
lord,
That is
this
the
is,
thing.
this
National
name
highway
is.
has not-
Oh, whether nation high accepts or not accepts, this is not the issue right now.
Yeah.
Let us have a satisfaction first that on the available basis of available material, damage has been caused.
Yeah.
So we'll pass an order, damage has been caused on, in this view. Therefore, we will direct the revenue authority to assess and pay.
Because here, my lord,
Huh? Within a time frame, that's all.
committee name itself Damage Assessment Committee. Which committee?
Because my
Okay.
lord,
8 members are there.
List this matter on as agreed to by the learned, or as paid for the learned counsel for the parties. List this matter on.
Except 6, huh?
next week, my lord, any day.
Next week may not be too many matters are fixing a matter is easy, but to complete all these are hearing matters.
Did you?
1st of October.
1st of October.
Ah.
Okay.
Publish.
Hey, we are trying to give them. That's what we do.
After, well, 8 years, well, they are issuing now to.
Now they, my lord, actually,
Revenue authority
they
is
want to
seeking, my
linger
lord.
this matter. In a nutshell, I'm telling, they want to
No,
linger the
no,
matter.
no further. Yes, Ganguly.
Oblige, you know.
This matter can be closed, my lord. In view of the affidavit filed by the Deputy Commissioner, the matter can be closed. Only 2 points, my lord. One is that the liberty to approach the DRT within 45 days of today. And the second is regarding the court fees. On this, my lord, if I may just raise one.
What was the prayer in this case?
In this case, the auction purchaser had come before your lordships, my lord, praying that the sale certificate should be registered. And finally.
Oh, that case.
That case. And my lord, that finally the DC has filed the affidavit saying that no, out of 3 dogs mentioned, the land actually only, well, the original landowner only had his name in respect of 2 dogs. So the sale certificate has gone. It has to be, my lord, I can't take possession of that land now. Now the.
So you do not want at this stage the sale certificate?
I cannot, because it is somebody else's land. The sale certificate bears 3 dogs, whereas the mortgager had only possession of 3 dogs, or 2 dogs. The state.
Heard Mr. A. Ganguly, learned counsel for the petitioner. Also heard Mr. K.P. Pathak, learned counsel for the respondent number 4. And MS U. Das, learned additional senior government advocate for the state respondents. Full stop. Anybody? Respondent number 3? No.
He is not.
Huh?
Actually, grievances against them, the Food Development Authority.
None appears for the respondent number 3. Full stop. The present writ petition is filed. No, the petitioner, anyway, the petitioner was the successful bidder in an e-auction dated 29/1/2016 by the respondent number 4 or 3? 4. HDFC Limited. in which the petitioner purchases certain land. Full stop. In terms of the advertisement of sale, a land measuring 2 bighas 3 kathas 9 nesas covered by DAG number 839, 842 and 843 of PP number 107 at village Doati Gaon, Mouja Bhairav Pod, second gate, Madhav Mandir, Tezpur, Assam was the subject land. The petitioner was successful bidder, and after paying the entire bid amount of rupees 750,000, the petitioner was issued a sale certificate dated 10/3/2016 under Surface Act and the rules framed thereunder. However, when the respondent number 4 applied to the Tezpur Development Authority for grant of sale permission, actually no sale permission is required. You will have to register the.
At that time, the law was very hazy. Now Supreme Court has more or less clarified the issue.
Clarified. It was not hazy. That was clear. I argued a case.
Yes, I think Lordship is referring to the 2007 matter of the Supreme Court in which it was referred. That will be like an auction sale. But still, whenever the process.
So certificate, you are the owner of the land. Thereafter, you file.
Yes.
But now you cannot get.
More or less settled, and the state has issued the requisite notification. Now they are not insisting upon registration also, and no NOC also.
Okay. Which was rejected by the concerned deputy commissioner on the grounds that as per the area of land as per revenue record is less than 3 kathas 9 lesas, and the authority had also insisted on obtaining NOC from the co-partners of the defaulting borrower. Full stop. This court under its order dated, where is the order? A filing of affidavit. This court under its order dated 25/6/2024, after considering the nature of the issue involved, has directed the state respondents, that is state respondents, to file affidavit in opposition. Accordingly, an affidavit in opposition has been filed. Full stop. It is contended by Mr. Ganguly that a specific stand has been taken raising some disparities in the land sold in the auction and the actual ownership of the land by the deputy commissioner. And in the aforesaid backdrop, according to him, the bank had misrepresented in the auction notice, and therefore the petitioner is not interested in pursuing the present writ petition or to get the sale certificate registered, more particularly for the reason that that it will be a futile exercise for him, and he will not get the possession of the land which he has purchased in the auction. Therefore, he submits that in view of the development, he may be permitted to withdraw this application with a liberty to approach the Debt Recovery Tribunal, Guwahati, assailing the action of the respondents, or to any forum which is available to him, assailing the action of the respondent bank. Full stop. Prayer is allowed. Accordingly, this writ petition stands course on withdrawal. However, it made clear that as the petitioner is wrongly litigating in this court, in the event application is filed before the DRT, the period of
Lordship will say within 45 days from today.
Provided that the petitioner is given a liberty to file such application if the petitioner files the application within 45 days from today, the learned Debt Recovery Tribunal shall not insist on the limitation.
Lordship will also kindly add one line about the court fees, because that has been settled by this court by a coordinate bench. If I may just.
Okay. in the event the petitioner files an application for waiver of
No, it's not waiver, it's a lower fees.
Huh?
It's a lower fees.
Okay.
Because I am an auction purchaser. I am not a borrower or mortgage.
Full stop.
There are 15 only.
Full stop. It is also observed that as the petitioner was an auction purchaser, he would come within the definition and ambit of any person under section 17 of the Act 2002, isn't it? Okay, Mr. Ganguly, we'll go through this and dictate this order. Okay. Dispose of.
That table is there in the act, in the rules table is there, that.
I will have to go through this.
Yes,
Okay. Come on, dispose of. Within 45 days from, we'll give a date. Because I'll have to see this.
Yes.
I'll see and I'll give my own reason. You will get after 2-3 days, and we 45 days will count from that day. Pathak.
Okay.
Tomorrow.
Very well.
This is tomorrow, already morning, tomorrow. By slip. Yes, sir. List this matter by slip tomorrow. Due to positive this matter, though this matter was continuously being heard, same could not be concluded today. List this matter tomorrow by slip.
I'll just add a few
Okay.
paragraphs from the judgments.